Yes.
I would like to mention item number 3, Your Lordship.
Yes.
But in this case, my lord, the English concept today could not be this case here. That the matter may become after 2 weeks. Your Lord.
Inform the other side.
Yes, my lord.
My lord.
On a prayer made on behalf of the petitioner, matter is adjourned by 2 weeks.
My lord, can it come up on 13th, my lord? 13th of August.
As requested, list on 13th of, 13th is Tuesday.
That is the hearing, madam.
It is not hearing,
Admission.
admission,
Admission.
12th, my lord.
12th.
Much obliged.
Trip. Yes, busy lord. It is for listing of the pension matter. Second. Pension.
Pension matter,
Pension matter.
fresh matter.
Between two eyes.
Now, is it a motion matter or what?
No, admission.
I mean, matter of which year?
Okay.
Matter of which year?
23.
23. Okay.
Last posting was
Okay, Friday.
17th.
Friday.
Right.
It was a common,
May I please, Lord?
yes.
My lord, I am paying for item number 31, Lord.
All open. 31, 31.
31, Lord.
Yes.
My lord,
What?
I am paying for upgrading the matter as the first hearing item, Lord.
Why?
The issue is very simple, Lord. Without issuing a notice, I am barred from service, Lord.
So
Without-
what is the urgency? What is the
Urgency,
exceptional case?
My lord, I am without job since
So
last
there are many other petitioners.
maybe, Lord.
Sorry, don't make this kind of prayers.
Lordship,
What is the exceptional circumstance to upgrade your matter?
I am without job last year.
Other matters are not important.
Every case is important, Lord.
Other matters are not important for you. Don't make this kind of, unless you make out an exceptional case that something is going to happen just now. Why upgradation? Yes.
May it please the court, your lordship, I beg to mention item number 14 from the daily list.
Yes.
The main counsel for respondent number 2 is out of town due to an unforeseen circumstance.
Who's the counsel?
Mr. Karan Khan.
You've been taking time on his behalf every occasion. Why?
Uh,
Last occasion, yes, your colleague was there.
so
Every time, every matter of adjournment on behalf of Mr. Khanna.
the,
We're not going to permit this.
your lordship, the last occasion time was sought by petitioner.
No, you are there. We don't grant adjournment on the behalf of council time and again. One occasion, two occasion, okay. You make alternative arrangements. We have facilities of online. What is the problem?
Your lordship, it was an unforeseen circumstance. We were,
Okay.
prepared to
Have you informed the other side?
Yes, your lordship, I am for the petition.
A prayer for adjournment has been made on behalf of the respondent number 2. Para, list after 2 weeks.
Lordship, can there be any particular date after 15th August?
2 weeks. Yes, next.
Lordship, I may be allowed to move 2 writ petition for admission hearing. The matter is about removal from service.
When?
Any date, Lordship, as per the convenience of the court.
Removal from service, you have got many other matters. What is the matter of which year?
Matter is that the.
Of which year?
It is in 2023 matter. The Lordship, urgency is that the petitioner is seriously ill. This is the only urgency. He is almost bedridden.
Not out of turn listing. Sorry. Yes, Mr. Mahanta.
My lord, item number 9, my lord, the hearing matter, my lord.
Yes.
The matter pertains to the DRS of cooperative mill workers, my lord, which was closed. Initially, it was contested, my lord. Now they are willing to take the money, my lord. The only difficulty, my lord, there are 44 petitioners, my lord. Few of the petitioners have already taken that amount, my lord. I have to get the list of those petitioners, my lord. I have taken the consent, my lord. My lord grants me 1 week's time, my lord.
17 matter, Mr. Mahanta.
Yes, my lord, it's not contested also, my lord. We are willing to take the money, but some petitioners have already taken the money. That list is not with me.
How does it matter? If you are not pursuing the matter, some of them have taken. What is the...
If the question arises, my lord, who had taken...
How does it matter? Somebody has taken, somebody will take. If you are not contesting, which you are stating.
Yes.
Withdraw this.
No, my lord, there has to be an order, my lord. They have calculated the VRS. we are willing to take that DRS.
Who's for the,
I've taken consent, my lord, Mr. G. Bodle, my lord, Gunjan Bodle,
have you done Friday? Ask him to have instructions.
Friday, my lord.
Oh.
Deeply applied.
A prayer for adjournment has been made by Sri P. Mohanta, Learned Council, for the petitioners by submitting that the matter is on the process of being settled outside the court. Full stop. He, however, submits that the details of such settlement is yet to be fully furnished to him. Full stop. Para. List on Friday.
Settled, not outside the court, settled, my lord.
Settled outside the court. Is there any court's order? There is no court's order. That is
I'll-
outside settlement. Okay.
May please the lordship.
Yes.
My lord,
Friday we'll have Mr. Mohanta. A date to give, huh? Yes.
my lord, I am paying for lordship indulgence to take up a matter, my lord, on Friday, my lord. Matter relates to selection and appointment of physically disabled persons.
Matter of which year?
My lord, it's matter of 2023.
What is the exceptional circumstance out of turn listing? Why?
Matter relates to selection and appointment, process is going on, my lord.
Sorry. Next.
May I please also, lordship, I beg to mention item number 15, my lord.
15.
My lord. And a hearing matter, my lord, Mr. Pishpuri, my lord, informed me that
In fact, my lord, he also requested me, my lord, from Delhi, he could not come today, my lord. As per convenience, my lord, may fix a date, my lord. It's a regulation matter, my lord, but they are engaged by contractor. And there is a, my lord, settlement also there. So settlement covers them, their case.
One case we have decided,
Yes, I have already given a copy to him, my lord.
I think Mr. Dasgupta was appearing.
Yes, for the petitioners and senior advocate Saibulasa,
Yes.
assisted by myself, we appear.
Yes.
I given one copy to him, my lord, already, my lord.
They were employed by the contractor.
Yes. Contractors and they also agreed to the.
A prayer for adjournment has been made
On behalf
on
of the
behalf
petitioner.
of the petitioner. Full stop. Sri B.K. Das, Learned Council, is present for the ONGC. Full stop. Para. List after 2 weeks. Yes. Next.
Obliged.
May I please, your lordship? Lordship, I'd like to mention for listing of the petition relating to a non-releasing of pensionary benefit.
Motion matter.
Lordship order.
Order. Pension. Matter of which year?
Lordship 2023.
Pension, okay, Friday.
Let's
may I present, I pray for listing of a petition of 2022.
22. What is the
Lordship,
matter about?
Matter is about lordship, a departmental proceeding was conducted. Wherein lordship, there were no list of witnesses, no list of documents, but even in spite of that, a finding was arrived that I am guilty. We filed an appeal, the petitioner preferred an appeal, the appellate.
What is the subject matter of
Lordship-
challenge? Where are you going to the facts? What had happened?
Lordship,
What are you challenging?
Lordship, I am challenging the inquiry report, and based upon the inquiry report, I had also tendered my VRS. Now, lordship, we are praying for setting aside of the inquiry report.
Sorry, not out of turn listing.
Please,
Next.
lordship. Sorry, I am mentioned for listing lordship in what's it WBC 1107 2024 matter lordship. Admission matter lordship.
24 matter, why are you making a
Lordship,
mention? What is the urgency?
Government has not filed affidavit lordship.
Sorry, next. Not out of turn listing.
My lordship. My lordship, my case number is WPC 1503 2024. It was last listed on 13 August, but returnable date is over. So my lordship, I beg to mention this.
What is the subject matter, madam?
My lordship, it's a selection procedure.
Sorry, next.
Not prayer for listing of one W
Of which year?
23.
What is the subject matter?
Matter pertains to a non-consideration of the candidature of.
Not a case for out of turn listing. Sorry.
I wish
Yes.
to mention for listing, my lord, regarding pension, my lord.
Pension matter. Okay, Friday.
Obliged.
It's a fresh matter or what?
No, for admission, my lord. Directed to list after vacation, but it.
Okay, we'll have it on Monday.
Okay.
Give Monday's list next Monday.
Lordship, I beg to mention for listing WPC service matter, lordship,
Service matter. WPC of which year?
2023.
23. What is the subject matter?
Lordship, till the person was prosecuted by the departmental proceedings, and later on, he appealed, the order set aside with the direction that was passed.
What is the subject matter of challenge? Why have you come to the court?
Lordship, the person was suspended, so he was silenced on that period.
should know what is the cause of action. That is not very difficult. You consult the facts, then come up tomorrow, not today. We'll
Lordship,
consider.
another matter was 2018 matter was there. Lordship.
18 matter, we'll have it Friday. Yes.
So Lordship, matter pertains to family pension, Lordship.
Family pension,
Yes,
okay.
Lordship.
Matter which year?
24, Lordship.
Last listed when?
One is 23 of March and another is 16 of February.
Response filed.
Yes, Lord.
They have filed affidavit in opposition. Not, okay, we'll have it on Monday next. Give the date, both pension matters.
Hello, Dean.
Your attachment order, you are challenging.
My lord, that is one limb of the grievance. My lord, the major limb of the grievance is that, my lord, I am a government servant under Directorate of Sports. Graduate, normal graduate plus diploma holder from National Institute of Sports.
Yes, you have got the instructions.
Received, Lordship.
Yes.
About deputation. I was interviewed. The
Guwahati,
state,
Lordship, since 2005, Lordship. 19 years staying in Guwahati.
No, is it a transfer?
that is-
Transfer, Lordship.
No.
This is the temporary attachment, Lordship.
in between transfer হৈছিল আকৌ, no?
It is a transfer.
Babe, have a look at page, all right, transfer. Who is going to replace me? Last page, page 48,
48.
48. Can it be done?
48.
In
Please read.
the interest of public service, so and so, Bosumotari contractual swimming coach at Gulaghat is hereby attached to the Office of Sports Authority. In my place, my transfer order is at, Page 30.
Temporary attachment, Lordship.
even then, in the name of temporary attachment, I have to go to Gulaghat,
Page 30.
page 30, Lordship.
30 is your order of transfer.
37.
37.
I am being sent to Gulaghat.
Mr. Chakraborty, you have all the rights to transfer, but this is not per se a transfer order. You're attaching him. Why do you attach? Transfer him if you find that his services are required in Golaghat. Transfer him. Your Parawest command cannot develop your case. Your object has to be reflected in the document itself.
This is the Lordship, kindly see the Shankar Bhuya Lordship swimming coach in the office of the DSO Kamrup is hereby attached to the office of DSO Gulaghat only, Lord.
Yes.
It is actually explained in this Parawest comment.
No, why attaching? How do you attach a person?
He is staying in,
No, transfer him.
And moreover,
This
that
is a
instruction,
transferable job as per your instruction. Transfer him, transfer simpliciter, matter ends there. Why this business of attachment and other business?
and this limb of instruction, my lord, that since 2006, I have never been transferred is absolutely baseless. 3 times I was transferred. Page 24.
since 2005, Lordship.
Anyway, page 24. 2010, I was transferred. Then page 25. 2011, I was transferred to Jorhat. Then page
No,
26.
that was 24 is for 15 days to conduct a training camp. That is not transfer.
Anyway, then
Page
this is the
24,
way,
then
my lord, there. So in any
conducted
case,
coach, not training camp. These are not transfers.
so in any case, I am showing that I was engaged in different places.
No, those are conducting for training camps for
It's all
15
right.
days.
It's all right. So she may take it that way. But can they justify this order? Question is there. And about the other limb, my lord,
You filed an affidavit, short affidavit, let us see.
My lord, one more thing.
Now let him file the affidavit. You are
There is another limbo.
you are protected by the interim order. We'll extend it.
Not only transfer. Initially, I said another limbo. The Central Government Sports Authority of India invited my lord persons on deputation from various coaching, swimming, coach. So my name was forwarded by state. I was called for an interview. I was interviewed. Then they requisitioned my document. That took my lord more than 1.5 years to send my credentials. Ultimately, Lordship may kindly turn to page 35.
3-5.
35.
Yes.
Because that is a broader field. Page 35. Now they are giving it to the Sports Authority of India by the Sports Welfare Department, directed to furnish here the following document. They waited, they did it after almost about 2 years. And on deputation, if I go, I get a higher price. More than that, my lord, it is a broader field for a coach.
This is a part of the retribution. He'll take care. File the affidavit.
Yes, my lord.
Heard Sri A.C. Borbora, Learned Senior Counsel, assisted by Sri M. Smith for the petitioner. Para. By the order dated 3/7/2024, Sri A. Chakraborty, Learned State Council, was directed to obtain the instructions. Full stop. The State Council has submitted that instructions have been received, whereby the impugned order of attachment has been sought to be justified. Full stop. Para. Let notice be issued. Returnable on, will give a date, transfer order, interim order is there. Returnable on.
There is a party, my lord, Sports Authority of India, my lord.
I'm appearing Lordship 1 and 2, Lord, not 3, Lord.
3, my lord, is Sports Authority, but 3 at Delhi, my lord.
Delhi, Lord.
So he is also an essential party, my lord. So far as the deputation is concerned.
Returnable on to the 31, 2 on 16th of August.
Lord.
Sri Chakraborty, the Learned State Council accepts notice on behalf of
Respond 1 and 2, Lord.
respondent number 1 and 2. Let steps be taken for service of notice upon the respondent numbers 3 and 4 by registered post with AD. Steps within 2 days. Steps by tomorrow. Para.
Okay.
By the next date, the State Council would also file the necessary affidavit in opposition. Full stop. Till the next date fixed, the interim order passed earlier shall continue.
Good.
Problem.
Mr. Chakraborty.
Wait, please, Lord.
Yes.
My lord, it is now before lordship frame for a limited pair, my lord. So inquiry proceeding against the petitioner is the logical conclusion, my lord. Because of that, my lord, they have to pass a order, my logical conclusion within a period of 15 days. That is over, my lord, they did not do it, my lord. So, my lord, I frame before lordship. Please may kindly see the inquiry report, page 59, my lord. Operative portion, page 64, my lord.
64.
64, my lord. Last conclusion parts, my lord. 64, my lord.
Just a minute.
May I read, my lord? Conclusion part, my lord. It can be concluded that although the charges have been leveled against Torani Kolita AFS based on AG observations and report, he is not entirely responsible for the mistake that happened in May 2022. He had done his duty in passing 6 numbers DPF bill as per authority received from the office of the AG Assam. Next, madam. The only mistake that could be attributed to him in entire process was that he passed the bill in respect of Srimati Kanchan Boru, wife of late Govindo Boru, without specific authority from the AG, madam. That part was at the time of COVID-19. There is a specific instruction from the government that minor DDO is the responsible. But I am praying before Lordship for concluding the departmental proceeding as stipulated.
Which
in
department?
minor finance department.
Uh,
My lord, as per
You,
rule-
you were working as what? You were working as what?
working in my lord as a accounts officer, my lord.
No, how, what prejudice are you suffering now?
My lord, because of that, my lord, if my lord, this departmental procedure is completed, then my lord, a national benefit has been given to him, my lord. And after retirement, there are so many cases are there, my lord, they did not pass it order and year and year.
What is the prejudice now you're facing?
Facing because of that, there is a stipulated that within 15 days they have to pass a logical conclusion. But-
You have said that, but what is the prejudice you are suffering now?
It is beyond my lord, before, within the 50 days, if they pass this order, that junior 42 juniors has already appointed, promoted.
Is
my
there
lord.
any restraint order
My lord?
for your promotion?
Yes, my lord.
Where is the restraint order?
There's a, preserve, my lord, my promotion was still covered, my lord.
Where have you stated?
My lord, paragraph, my lord, the Panalu could permit me, my lord.
Page?
My lord, para 21, my lord.
2-1.
2-1, my lord.
Page?
That page 14, my lord.
Yes.
That it is humbly submitted that it is no longer raised that during the pendency of department of if the incumbent comes within the zone of consideration for promotion, his case is to be considered and kept in field cover. Thereafter, once the said income is either exonerate or completion of the penalties imposed by field cover has to be opened and recommendation made there is to be acted upon by way of promoting the incumbent. Further, if the penalty there was nothing regarding the seniority, then even his seniority has to be restored. As stated above, in the meantime, many juniors colleagues of the petitioner has been promoted to the next higher post. Be that as it may be, in the instant case, the authority being fully aware that petitioner is going to retire, so they are deliberately setting over the inquiry report 29/6/2004 so that petitioner unable to avail his retirement benefit. As such, the honorable
Mr. Bora, you have come to the court just a day before your retirement.
My lord,
But that doesn't mean that if you are successful in this case,
my lord,
you would not be entitled to the promotion. If you are successful, you will definitely get to
my lord,
the benefit of the promotion
my lord,
by opening the seal covers.
my lord.
But as on today, what
lord,
order?
my
Yes,
parents-
Madam, you take
We'll have to give
instructions.
the instructions a lot.
Get the
right?
instructions.
Yes, sir.
We'll have it on, today is what, Tuesday? We'll have it on Monday next. Get the instructions, okay? Third, 3 N Bora, Learned Counsel for the petitioner. Full stop. The petitioner who is serving as finance and accounts officer
My lord,
in the office of the Superintendent of Police, Dhemaji,
my lord.
he is on the verge of retirement. Full stop. A departmental proceeding was initiated against him. In the wide initiated against him on 4/2/2023, and it is submitted that such proceeding is yet to be brought to its logical conclusion. Full stop. The petitioner has also made out a case that because of the pendency of the proceeding, comma, while his juniors have been given the benefit of promotion, comma, the petitioner has been left out. Full stop. Para. Let instructions be obtained in this regard. Miss, your name?
RM Barua, Your Lordship.
RM Burra. Ms. RM Burra appearing for the HLE.
Yes, Your Lordship.
You are not the standing counsel.
No.
RM Barua, Learned Counsel appearing on instruction of 3 Chalia. Standing Counsel Finance would obtain the necessary instructions. List on Friday, Monday next
Mark,
Thank you, Lord.
for motion.
Mark.
May it please your lordship. Your lordship, my senior Mr. Kane Chaudhary will appear in this matter, your lordship, and he's on legs in another court. Kindly pass over the matter.
What
for
is the
time.
matter?
Your lordship, the matter is, we are challenging the age of superannuation, that is 65 from 70, your lordship. And we were working under the government of Assam at erstwhile mental hospital, your lordship. But then after the abolishing the erstwhile mental hospital, we have been absorbed by the government of India. And after that, we have been rendering our service as government of India employee, your lordship. But since then, we have not
What is
received
the
any
age of
service.
superannuation so far as government of
It was
India?
65, your lordship, but after the notification of 2022, it has been increased to 70 years, your lordship.
But it is
but
actually
recently-
65. What is your age now? 60.
No, your lordship, we are 65, we are turning 65 in 31st July, tomorrow, that is. So we have received a letter and they have asked us to
Sir, doctor?
retire, your lordship.
What do you say?
Inspection is necessary, my lord, they are here. But the institute of mandate asylum was taken over by the government of us, or government of India,
Hmm.
pursuant to a direction of the Supreme Court. And as per the agreement, they were the employees appointed by the government of Assam. Were absorbed by the in the government of India. My lord, as per the agreement signed by the both parties, that the employees absorbed by the government of India who were appointed should not be appointed their position in the future. They will not be affected in any manner.
Okay,
And-
well, let Mr. Chaudhary come then.
Tenure is not there, my lord. Appointed by the observation of this honorable court. And
You show us those positions. Let Mr. Chaudhary come
Yep.
after a while. Got the records?
My lord, I have not got a record, my lord. So we have written the letter, my lord.
Get the records. It's a disciplinary proceeding.
Yes,
Madam, your client was working as what?
He's a ABC in Dibrugarh.
Constable.
Armed branch constable.
Yes.
Now under, you have been dismissed.
No, he's not been dismissed. He was reinstated within a year's time only.
Stoppage of-
Stoppage of 5 numbers of increment.
Stoppage of increment.
Okay, get the records.
Right.
But it's a matter of 2020. Get it early.
Yes, yes, my lord, I will try.
Okay. Sri T. Shi Chutia, learned additional senior government advocate, has renewed the prayer for adjournment to enable him to obtain the records of the departmental proceeding. Full stop. Para. Further time of 3 weeks is granted. Full stop. Para. Considering that this matter is of the year 2020.
Yes.
Let the matter be fixed on 22nd of August.
Deeply open.
Let
my lord, please.
Please, Your Lordship, Mr. HLA appears for this matter. As my instructions, we will be filing our affidavit today, Your Lordship.
Okay, who has filed affidavit? Who is R3 and R4? Revenue Department. R4 is the government.
R4. Yep.
Okay, you file, let them,
The finance filed the affidavit yesterday.
No,
they have given you a copy, they'll be filing today, I think.
filing it today, the report.
While the revenue department and the, and Mr. Borafo, for the, and the deputy commissioner and the district commissioner has filed the affidavit in opposition, comma, the finance department, the learned counsel representing the finance department has submitted that the affidavit in opposition would be filed during the course of the day. And in fact, advance copy has already been furnished to Sri Chaudhary,
Yes, madam.
learned counsel for the petitioner. Full stop para. Accordingly, list this matter on Monday next, along with the affidavit that may be filed today.
Right. Madam, I kindly passed over for a time being, Mr. H. Gupta Lokiri is on late, PG Lord. So his presence will be required, Lord, and matter is relates to the copies of pension. Because he was initially granted. pension.
Time being difficult one matter we've already passed, okay. For some time. Madam, here for H. Gupta.
No. 3 matters are there, in one matter, Kegogo is there.
Is he there in the court?
Both late, sir.
Okay, after some time,
Yes, sir, that. All right. Happy Jalo. My lord, this matter posted on 29/7 before the Lordship Court, my lord. So far as respondent number 5 is concerned, with the service is complete. And I love to also Lordship draw attention at 8 May order. We have discussed affidavit of the respondent is necessary, my lord. My representation is also pending. They are please unable to direct that in the meantime, but same has not been done here.
R5 is complete. R8, who's R8? Now you said so affidavit of by whom would be required?
My lord,
You said just now you had submitted affidavit by somebody would be required?
my
Who's
lord,
respondent? Which respondent?
mainly, my lord, respondent 5 Nalbari Municipal Board, my lord, executive officer.
R5 has been
Yes.
added later,
Yes, respondent 5 dated letter, my lord.
amended,
Already. Yes, my lord.
whose affidavit would be necessary?
But since all the respondents, my lord, they are
Mr.
representing
Chutia?
municipal board, Nalbari is important, my lord.
Mr. Chutia?
4 and 5 mainly.
Mr. Chutia? This matter, no response has been filed. Heard Sri P.K. Deka, learned counsel for the petitioner, who has referred to the order dated 29/7/2024, passed by the learned Law Jima Court. Full stop. Peruse the said order. Para. Service upon respondent number 5 is held to be complete. Para. Sri T.C. Chutia, learned State Counsel, learned Additional Senior Advocate, prays for and is granted 3 weeks' time to obtain the instructions / file affidavit in opposition. Para. Since the matter pertains to arrear salaries and other post-retirement benefits, comma, let the next date be fixed on 21st of
My lord.
August.
21st of August. Deep
Obliged.
level.
Post-retirement benefits, please.
Yes, yes, well, Lordship, here the petitioners in all the writ petition, three writ petition, but the petitioners were serving in the Lordship Assam Rifles. And they were as Havaldar Lordship, and they were prematurely retired from the service Lordship. And at the time of premature retirement, they were given all the pension benefits, pension, etc. They were receiving everything. But being agreed by the Lordship premature retirement, order of premature retirement Lordship, the petitioners approached the Honorable Guwahati High Court Lordship. Then the Honorable Court observed that the premature retirement, the order of premature retirement is illegal Lordship. But since the petitioners crossed the Lordship age of superannuation, so they said that the matter become infructuous. Challenging that order Lordship, the petitioner again approached the division bench. Then Honorable Division Bench said that since the order of the premature retirement was illegal, so he is entitled for the superannuation pension, and he should be notionally treated to be in service till the age of 60 years. So in terms of that order, the respondents have agreed and they have complied also. But Lordship, in the meantime, now they are by the impugned order, they are saying that you first refund all the amount that we have given you at the time of premature retirement, pension, gratuity, everything. Then after we will start your pension, Lordship. Otherwise, they are not releasing my pension. They have stopped my pension in August 2023, asking me to refund. And we are saying, Lordship, that we have prayed also that you adjust the amount that what is required. And in the similar line, Honorable Lordship.
Yes, sir, Mr. Gupta, not a very difficult matter, I think.
The matter only pertains to adjustment of the amount
Yes, yes.
which has to be
No,
recovered.
but tell us one thing. Whether it's a premature retirement according to them, which obviously, it's a different matter. The court has held it to be premature.
No, no.
And whether it's a retirement as per their claim that it should be on a particular date. There may be a difference in the emoluments amount, but I don't think there is any difference in the mode of payment.
That is the problem, my lord. That is why we are not able to recover.
Is there a difference in the mode of
Similar issue.
payment? Was
Yes.
a lump sum given at the time of,
Yes, my lord. That is
and
why-
now he'll given on a monthly basis or what?
No,
Presently,
Now, my lord,
presently, is there any difference in the mode? We are asking on that. How do you pay the superannuation benefits, post-retirement benefits? As a one-time payment,
earlier, no, it's monthly, my lord.
monthly wise?
Monthly wise.
So earlier was any lump sum
No, no,
payment
monthly
given?
No, no lump
then
sum.
You adjust it.
Gratuity and all, my lord, few retirement benefit, that has been paid lump sum. Otherwise, pension is.
That otherwise also you have to, gratuity is not, we are only on the pension benefits.
But now since the honorable court has passed an order enhancing the date of benefit, now is deemed to be superannuation.
On a
at the age of
future
60
date,
years. So
yes.
all the benefits gradually increase, my lord. The gratuity benefits, leave in cash, and everything has been enhanced.
Mm.
So only difficulty is, my lord, the pension and pay allowances, they fall under one head, and my lord, the payment of gratuity falls under different head. There are two heads, my lord. One head comes under Ministry of Finance and one comes under the my lord, Ministry of Home Affairs.
Will there be a change in the amount of gratuity also? There will be.
Yes, my lord, we have calculated, my lord, we'll see page 3, my lord, the instruction which I.
What is the difficulty in adjusting?
Yes, my lord, there is.
Should not be a
should not
difficulty.
be
A similar order, in the similar case order has been passed by the Meghalaya High Court. Your Lordship,
No, you have a look, Mr.
My
Gupta.
lord. Have, no?
Honorable High Court has said that just adjust it from the Lordship, the current salary, the superannuation pension.
No, that is it.
That is the only Lordship. And since 2023 August, their pension has been stopped, Lordship, without a single penny for the last 1 year. It will be 1 year from the next month. That cannot be, Lord. And they were receiving since 2008 to 2023 receiving the pension, Lordship. And the Honorable Division Benches clearly stated, Lordship, that you just calculate it and pay the amount, Lordship, at page 37, the observation of the Honorable Court.
Mr.
It can
I
be
don't think this is fair on your part.
to withhold the pension.
Yes, this is not fair. Wholly unfair. Why should he come to the court again? Who are the officers? Have you filed affidavit?
No, Lordship, instruction limit not.
I have received the.
We have understood because he has come to the court, you are taking this measure.
Well.
Let them come.
My lord, paragraph.
Let them come. Let them come.
My lord will take my lord
After
paragraph.
DB has passed the order, where is the scope
My lord.
of stopping pension for 1 year?
My lord, my lord, now we have calculated what is the due amount, my lord. My lord can dispose it in terms of the direction, my lord. My learned friend has pointed out. Page
So this
three,
practice is not.
I agree, my lord.
This is only a vindictive kind of a measure. You have approached the court. We have withheld your pension. You withhold your pension. He comes to the court. Explain why you withheld the
Lord, is there
pension.
two
We don't
different-
need a counsel.
My lord,
Matter ends there.
Page
my lord,
Who has taken the decision?
if my lord issues a
Now,
direction.
who
my
has
lord,
taken the decision?
Lordship, at page, impugn order is at page 39.
Let the Director General Assam Rifles come.
Page 39.
Let us understand from him where he got the power to withhold the pension.
For the last 1 year, Lord, without a single.
If you are agreed by the DB, you go to the Supreme Court. Can you circumvent an order and have a vindictive kind of an order?
my lord, my lord will give me, my lord, 1 week's time, my lord can dispose of also, my lord will.
We'll have this on Friday. You come
No.
up with instructions that you have adjusted.
My lord,
Otherwise,
my lord.
we'll take a serious exception to
No.
this matter. We'll make some indication in this order itself. Third, 3H Tahbildar,
AR topic.
AR Tahbildar, Learned Counsel for the petitioners. Full stop. Briefly stated, comma, the petitioners being aggrieved by their premature retirement with effect from 1/11/2008 had earlier approached this court by filing writ petitions. Full stop. Initially, those writ petitions were disposed of by the learned single judge, wherein the illegality was noticed, but observing that in the meantime, the petitioners had surpassed the completion of 30 years of qualifying service, had closed the writ petition as infructuous. Full stop. The petitioners thereafter had preferred writ appeal, different writ appeals,
Different.
writ appeals, and judgment was common or what?
Judgment was common, Lord. Not common, Lordship, in three separately, Lord.
Not
It is
different dates.
Same.
Same date, my lord.
Same date.
18/1/23.
Latest same.
And wide judgments passed on 18/1/2023
18/1/2023.
had allowed the appeal by directing for calculating the pension and other post-retirement benefits as on the date of the actual date of superannuation, which according to the petitioner was on the subsequent dates, were on subsequent dates. Full stop. Para. The instant writ petitions have been instituted as from August 2023, the pension has been stopped. Full stop. The representation of the petitioners to make adjustment of their entitlements have not been paid heed to. Full stop. Para. It clearly appears that the impugned action of stopping pension from August 2023 is a vindictive measure taken as the petitioners had approached this court and their grievances were redressed. Full stop. Para. Without making further observations on this issue, comma, this court grants time till Monday next to Sri H. Gupta Learned CGC to obtain instructions regarding the steps taken for adjustment and final orders passed in this regard. Full stop. Further delay in this matter would entail passing of orders, including orders of personal appearance, to explain the conduct of the respondents. Yes. Oh. Is it there in the court? Otherwise, and duita diba, huh? Item K Gogoi and Sri Swens. Yes, next. Item 8 for hearing.
May I please your lordship, my lord? My lord, at the outset, my lord, on the last occasion, my lord, and the matter was heard, record was called for. Record was directed to be produced with the court. Matter relates to a departmental proceeding. My lord, and in terms of that departmental proceeding, ultimately, my lord, they took a disciplinary action by dismissing me from service. Initially, my lord, I was appointed, my lord, in Assam Gramin Vikas Bank, which is a joint undertaking of Government of India, of Assam, and the then United Bank of India. Now it is merged with Baroda Bank. And while I was working, my lord,
When were you appointed?
I was appointed in 1985
As
PC, part-time cashier, multi-purpose, office assistant,
1985.
85, 4/12/85. At para 4, at page 8.
Yes, okay, then.
Then while I was working in Balpara branch during the period from 5/4/2001 to 27/2005, there was some, my lord, irregular act took place in the form of obtaining, in the form of opening a irregular account in the name of one Nirupam Das. And our account was opened, money was, initial deposit was made, ultimately money was transferred to that bank and it was withdrawn. And later on, my lord, while I was transferred from this particular branch to Subapara branch, I received a notice, my lord, by the annexure A, 3/12/2021.
Page.
At page, my lord, annexure 8 at page
51.
51. By the way, I was directed to appear before an inquiry committee, which was proposed to be, my lord, conducted by the management of the bank. And I appeared in terms of that notice. Inquiry was conducted by senior manager.
That was the investigation, not an inquiry.
No, whatever it may be, investigation. That was fact-finding investigation. I appeared, my lord, one senior officer, senior manager.
Okay.
He was appointed as inquiry officer. And in that case, my lord, my statement was recorded along with many other persons. Ultimately, a report was submitted, which I can say is a preliminary report. I was exonerated from that allegation.
Page.
Page, my lord, Actor B.
This B is your
Actor
statement.
C. Actor C.
54 to 55.
Yes, 54 to 55.
Yes.
And 3% pyramid of liability was picked on 3%, and our lawsuit will find at page 55. Islamuddin Ahmed, Singh officer, Rangila Nath officer, and Mukul Das, manager.
You are Mukul Das.
Now I am Mukul Kalita. Then all of a sudden, my lord, immediately thereafter, I was directed to pay, my lord, some portion of the amount misappropriated. Direction was issued, then I, compared with the direction, I deposited 1,30,000.
Why
Out
did
of
you
pay-
pay? You are not guilty. Why
I
did
am
you,
not guilty. I was directed to, my lord, deposit. I deposited.
why did you deposit?
Then, my lord, this way, that way, my lord, I complied with the order, I deposited. Then, my lord, they issued stop-loss notice, saying that, my lord, I am the whole architect of the entire episode, my lord. And development process was initiated. My lord, notice was issued upon, my lord, presenting officer, inquiry officer were appointed. I was, of course, given an opportunity to be represented by an official of my choice. And, my lord, interestingly, and I said the, my lord, which is not at all permissive. The inquiry officer, my lord, he was initial, my lord, investigator. He was appointed, he was examined as a, my lord, witness of the department. And he made all statement against me. Basically, they relied on some report of FSL. So you will find in the inquiry report. That particular handwriting expert was not examined. And entirely relying on the evidence of, my lord, that material witness. Lord, his name is Ghosh. Hori Ghosh. Hori Ghosh was the initial inquiry officer, and he was engaged. He was examined as a material witness on behalf of the department. He made evidence, and on the basis of that, my lord, I was found guilty of the charge. Then I was directed to submit the reply. I submitted my representation. Then one more, my lord, opportunity was given to me. I consistently took the same stand, and they ultimately arrived at a conclusion. Of course, my lord, in between, I was directed to appear before vigilance officer. Vigilance officer, my lord, initially, my lord, asked me to put a signature on the blank paper and recorded my statement. Later on, it appears that, my lord, on the basis of undertaking given by me, they issued the, my lord, termination order. So, my lord, if I had the, my lord, frustration or relation or whatever it may be, to, my lord, realize my guilt and made a statement that I'm sorry, that I would not have appeared in the, my lord, department proceeding. I would not have, my lord, taken this stand that I am totally, my lord, innocent. And report will say, my lord, initial report, my lord, I did not have a single involvement. Now they are saying, my lord, in their affidavit that everything was done by me. As it appears from the FSL report, my handwriting matched with the, my lord, handwriting, and written, my lord, appeared in various documents. But that FSL officer, my lord, a handwriting expert was not there. So in that situation, will it be, my lord, appreciable or acceptable to rely entirely on the report of the FSL? So this is the case in short, my lord. This is the stand they have taken. They have said, this is the FSL report speaks, allows everything against me, and I confess my guilt, and ultimately, my lord, my service was, my lord, terminated, dismissed. I was dismissed from service in terms of Regulation 39(2)(b).
Which date?
My lord, I'm just taking a lordship, my lord, for a moment.
Date of dismissal?
Yes, my lord. At page, my lord, annexure, termination order, X. At page, my lord. At page 116. Pursuant to the letter dated 23/4/14, your personal hearing in response to it with regard to proposed punishment, I have carefully considered your submission in the background of the charge leveled against you, inquiry proceeding, connected papers, document, inquiry report, etc. In view of the facts and circumstances of the case and gravity of the misconduct, and considering your prayer in respect of the proposed punishment, I have again applied my mind and have come to the conclusion that the proposed punishment commensurate with the gravity of the misconduct and it cannot be further reduced. Therefore, impose under mentioned measure penalty in terms of regulation 39(2)(b of Assam Gramin Vikas Bank Officer and Employees Service Regulation 2010. This is the order. So it appears from this order that basically they relied on the commitment or statement I made, secondly, matter of inquiry report. Now, Lordship, have a look at the matter of inquiry report. At page 97.
Yes.
Yes, madam. Ninety kото?
97-102, 97.
At page 99, inquiry report. In the matter of departmental inquiry into the charge level against Sri Mukul Kalita, so Assam Gramin Vikas Bank, Dubapada branch, in terms of the bank's charge sheet dated 27/12/2012. The chairman, being the disciplinary authority, referred to as a disciplinary authority, and after, through this letter dated 15/3/2013, appointed the undersigned as inquiry officer, and thus the undersigned acquired jurisdiction of departmental inquiry as inquiry officer. In terms of the said letter dated Dhubdara appointed as presenting officer referred to as PO after of the case to present the bank case at the inquiry. The proceeding of the inquiry was fixed on 25/5/2013 at 1:30 p.m. at Assam Gramin Vikas Bank, Dudhnoi branch. A notice in this connection was issued to concern, including the charge sheeted employees, by yours letter dated 16/5/2013, advising to appear before the inquiry.
This you can skip, you can come to the main
Yes.
portion. They have,
Then at page 101, the charge was pending.
they had exhibited 16 number of documents.
Yes, 16 number document.
And the investigation officer in preliminary inquiry, he was produced as a witness.
Yes,
You did not produce any defense document.
yes.
Then charge
That-
number 1.
Charge number 1. One SB account opened on 23/3/2005 in the name of Sri Nirupam Das. Address so introduced by one Gunindra Mehdi. That person was not introduced by me, somebody else introduced. Office of District Agriculture Officer Balpada. His account number is so, and Mehdi denied to have introduced the said SC person, and he was not known. Ultimately, my lord, they fixed a liability on me, saying that I made a statement, I made an assurance that I will press out the person, bring the person before the authority.
Where is the reflection?
Yes. I'll come, my lord. I'm just pointing out. Then he does not know. And that Gunin Mehdi was not examined, not, my lord, allowed to be a cross-examined. Brief as under PO to prove the charge produced by material, my lord, Exhibit 4 and ME5, ME6, pro witness report inquiry and MW1 confirm the same before the inquiry. ME4 SB opening form, ME5 SD specimen card, ME6 SB deposit slip, also PO proof, the handwriting of the SE opening form, specimen card by ME 18 throw so. Then DR argument. The DR argued that PO could not prove it as per the senior manager instruction to open the account in presence of the passing officer. The signature taken by Mukul Kalita, CSE, hence charge not established against Kalita. That charge was not proved against me. Then PO finding. PO presented ME4, ME5, ME6, ME16 to prove the charge before the inquiry officer through MW1. ME4, all handwriting in the opening form of M. Kalita's CSE. ME6, all handwriting in the specimen card is M. Kalita's CSE. In Tonto, ME6, if in case deposit voucher in the name of Nirupam Das, in ME16, proof documentary evidence, hence charges established. So on the basis of these materials, ultimately charge number 1 is proved against me. I said it is not proved, they said it is proved. Charge number 2, in brief. Account holder Nirupam Das was not known to anybody in the locality as per Gwalpara branch. All the opening form, specimen card, filed by you as Nirupam Das. They may not fix the liability on me. Everything was done by me. Whereas in charge number 1, basic charge is that he was introduced by one Gunindra Madhi. Then PO, presenting with a brief as under. PO to prove the charge by produce the following document. ME4, ME5, ME6, ME16, Pro MW1. It is evidence against the charge number 2. All the handwriting ME4 to ME6 is written, so charge is established. So on the basis of materials, charge number 2 is proved. DR argument. DR argued that CSE Kalita is filled up the opening form, specimen card, etc. in the name of Nirupam Das, but account is authorized by authorized officials, so he is not responsible. Hence, the charge has not established against Mukul Das. This is our argument, Mukul Kalita. EO finding, inquiry officer's finding. PO presented ME4, ME5, ME6, ME16. The CSE Kalita written ME4 to ME6, and it proved by ME16 through MW1, hence charge is proved. Except by giving some reference of certain materials which was executed by the management. No reason, nothing of this should not find. As Lordship has already pointed out, in what manner they have held the charge proved against me. And charge number 3, in brief, 4 numbers of withdrawals were made in the account of in the account on 12/4/2005, 13/5/2005, 23/5/2005, and 27/5/2005 for rupees 1,50,000.
Mr. Pokasta, we have gone through this report. There are 5 charges, 1 to 4 have been found to be established, 5 is found to be not established. What are your grounds of challenge?
Basically, in short, my lord, without referring to any document, I say that, my lord, you cannot examine the initial investigator. Because
Why?
he took a decision in my favor. Subtila, how can he turn?
No, where is the Bahar?
My
A
lord,
person who had made a preliminary inquiry.
whether a person can have 2 voices, my lord.
He's not having a voice, he's not being.
Because initially he said no materials is found against me.
So
I was exonerated.
So you should be happy that a person who has made a decision in your favor was examined by the management
My lord.
and his statement was taken. His statement is not the ultimate thing. The inquiry officer has given a report.
He did not make a single word in, my lord, in course of, my lord, inquiry that initially there was a preliminary inquiry. I conducted the inquiry. I didn't find anything against him. Not a single whisper, madam.
We'll see from the records.
Because these
But-
documents are not, madam, subsequently procured. These documents are very much available at the time when
But
first inquiry was
is there
conducted.
a bar in law? Suppose in a case where a criminal case is on, the IO is brought to a department proceeding for
Madam.
inquiry as a witness, he
Madam.
can be.
Because, my lord,
Where is the bar?
my lord, normal proposition of law is that, as I understand, subject to what my lord says, my lord, if a person took a stand on the basis of certain document, subsequently, how can he turn back? Madam?
Has he turned?
He'll be stopped by his own conduct.
Now, is the inquiry officer and the investigation officer the same person? He's not the same person.
Person.
How is it the same
But
person?
Sanjay Ghosh, my lord, he is the initial
The
investigator.
investigation officer was Hari Ghosh,
What do you go? He is the same person.
who has done the inquiry.
No, he was examined as a witness.
That is it. He's not the same person. He's not the decision-making authority. Investigation officer was Hari Ghosh. Inquiry officer is somebody else.
Inquiry was
Hari-
someone else.
Hari Ghosh has been brought as a witness in
right.
the inquiry.
Yes, yes.
There's no bar as such.
Therefore, Lord, what I am trying to impress upon that, my lord, you had number of options. You could have examined a better witness. You chosen a particular person who conducted an inquiry in my favor.
So
Therefore,
you should be happy about it. How is it caused prejudice to you?
I'm not happy, my lord, because he
You
took a
should be
time
happy even
to
if
make a statement against me,
See, Mr. Purkasta,
My
even assuming that the
My lord.
initial investigation,
my lord,
the report was against you,
my lord.
would that have precluded that person who had made the investigation be examined as a witness? There is no bar.
My lord, that then situation would have been otherwise.
Why?
If initial report is against me, then I did not have anything to say.
Why shouldn't it?
Because earlier
That is a
inquiry,
fact-finding report.
my lord,
That is not a proper departmental proceeding inquiry which is contemplated under the law.
maybe, my
They
lord.
can do a preliminary fact
Maybe,
finding
my lord.
inquiry and
For
they cannot
example,
take
my
any
lord, for example, as your lordship knows, my lord, quite experienced, my lord. My lord, in a department proceeding against a sexual harassment in the, my lord, workplace. The preliminary inquiry report, fact finding inquiry report, that has got a lot of significance. Because summary inquiry is to-
Mr. Purkas, don't bring that. That is governed by a statute entirely. Statute is a self-contained code. It lays down what is the role of the preliminary and how is the report to be regarded. Is there any requirement of a further inquiry? That's a different act, different statute.
my lord, since you were not at all in a position to ascertain who has done, my lord, what. Therefore, you proposed to conduct an inquiry.
See, our role in matters of disciplinary proceeding is very limited.
My lord,
You can make a challenge, base
My-
your challenge on procedural aspect,
my,
that you are not given a proper opportunity to safeguard your rights.
my lord.
Number two, if you go on the merits, you have to make out a prima facie case perverse, that is a perversity. The findings is perverse to the materials on record.
That is, my lord, of course, my
Unless
lord.
you-
Yes. And my case is that, my lord, number one, the original investigator, he cannot be, my
No,
lord,
that we are not
This-
accepting.
court is not going to accept it. All right.
That we are not
Then
accepting.
inquiry report says they relied on FSL report. FSL, oh, my lord, handwriting expert was not examined. I didn't get an opportunity to cross-examine him.
Where is FSL?
Yes,
Where is the observation in the inquiry report?
who has it, Rondo? FSL. It is true, yeah. Presenting officer. My lord, Lordship kindly come to it, page 90.
90.
90. This is the note prepared by, my lord, the presenting officer, one Shapan Kumar Saha,
Yes.
to, my lord, Rakesh Sharma, inquiry officer.
This is the written brief of the presenting
Yes,
officer.
some short brief, etc. At page, my lord, the above documents of Kolpara with the branch. Somewhere I have found that. The episode inquiry, entering expert opinion from.
Okay, what are your other grounds?
These are the two basic grounds, my lord, because
Now,
Proceed.
you had urged only one ground, that the investigation officer could not have been made a
yes,
witness in the department
Yes.
proceeding. That is one.
that
What
is
are-
one. Another is, my lord, handwriting expert. Handwriting expert, they state that, my lord, the signature is found to be, my lord, signature of mine. The signature appearing in documents is the signature of the petitioner.
Hmm. What is the ground?
And whether they can entirely rely on that report of the handwriting expert.
No, that is not reflected in the inquiry report.
My lord, but my lord, it reflected in the, my lord, brief of the presenting officer. Brief of the presenting officer in respect of charge number 2 at page 92.
Please read.
At page 92.
Please read.
Yes, I'm reading it. At page 92. Charge number 2, I showed ME 4 to ME 1 and argued that the handwriting of CSE is similar to ME 16. Sri Tilak Das, of Scientific Officer of Director of Forensic Science, Assam, stated that SL number 1 to 24 written by the same person, handwriting in similar to Mukul Kalita. That might be, my lord, one of the ground, because presenting officer presented the case, apprising the inquiry officer that handwriting expert has given the view against the petition. Therefore, am I, my lord, entitled to at least to have an opportunity to cross-examine the handwriting expert, or whether they are otherwise obligated to examine handwriting expert method. The photograph affixed in the account opening form is not known to any bank official. In reply to charge number 2, CSE informed that the account holder is known to him and account opening from all checks, withdrawals was filled up and written by himself. In reply to CSE 1, argued that his malafide intention is proved and established that the siphon of money drawn by himself for his personal gain, as per ME 16, Tilak Das, the scientific officer of Director of Forensic Science, Assam, stated that SL number 1 to 24, written by same person, whose handwriting is similar to Mukul Kalita. The CSC stated that he knows Sri Nirupam Das and he is residing outside Assam. and account holder will produce before the quasi judiciary within 7 days. Initially, you did not, my lord, make any charge against me that account was introduced by me. That was introduced by a small group, my lord, Medhi. Now you are saying, my lord, I introduced the account holder and I made a commitment to bring the account holder before the quasi judicial authority within 7 days.
Did you bring that?
No.
Why?
No, because I didn't know about that person. No. I never introduced that person.
But
Initial charge was that somebody else has introduced.
But he had denied that particular officer made. He had denied that he had.
He denied. Medhi was not examined. Medhi was not examined. They, my lord, perfunctorily they come to a conclusion that it is me who have introduced the account holder. And therefore I made a commitment to bring him within 7 days. My lord, in the inquiry officer, my lord, all officers are stating, my lord, I am the single person. And what was his mental state of mind at that point of time? And under what circumstances he made the commitment? But what you had done, your initial charge is something else. Now you are trying to shift the entire responsibility on me, that all documents are prepared by me, all documents are signed by me, and that too on the basis of report of FSL. An FSL handwriting expert was not examined. As far as the procedural part is concerned, my lord, I think, my lord, to be honest enough, frank enough, my lord, there is hardly any irregularity. I was given the opportunity, I was allowed to be represented. Of course, my lord, my representative was not, my lord, as skillful as he ought to have been. Now I cannot blame him. But I have chosen that person, he represented me, and of course there is some lapse on his part. What he ought to have done, he didn't do. I cannot take that advantage. And lastly, my lord, that you, my lord, took a personal hearing. And you, my lord, asked me to appear before the vigilance officer. When the entire proceeding is concluded, I was asked to submit my reply.
But that is not one of the materials which have been taken into consideration by the inquiry officer, neither the discipline authority.
See the, my lord, last order.
Page.
Impin order. At page, last order at page, my lord. Original copy I have annexed. Annexure X. I have
Yes.
already written, my lord.
Yes.
Already written, my lord. Referred to.
Yes. Where is it?
Pursuant to letter dated 23/4/24. This is the letter whereby I was asked to appear before the vigilance officer.
Yes, that is
And
not.
your personal hearing, in response to it, with regard to proposed punishment, I have carefully considered your submission in the background of the charges leveled against you, and you and inquiry proceeding, connected papers, documents, inquiry report, etc.
Mm.
In view of the facts and circumstances of the case and gravity of the misconduct, and considering your prayer, and what is my prayer? I will refer it back, my lord. Just a moment. Prayer in respect of the proposed punishment.
Mm.
I have again applied my mind and have come to the conclusion that the proposed punishment commensurate with the gravity of the misconduct, and it cannot be further reduced. Therefore, to some extent, that my lord took into consideration what was my statement before the vigilance officer.
No, there's no reference at all. Rather, at 114, your personal hearing, your
That personally before vigilance officer.
yes, 114. See that is not personal hearing before vigilance officer.
Yes, yes.
Kindly see 114. Read the contents. Don't make a submission like this.
23/4.
No, 114. The annexure W. I think there is some pagination fault. Annexure W. Maybe 113.
114.
Maybe 113. Maybe. We'll not know.
114.
Just one page before the impugned order.
114.
Personal hearing.
Personal hearing.
Please
At
read.
page 105. Annexure W.
Yes.
23/4/2024.
Please read in
In
compliance.
compliance with the head office. Transfer is also dated 23/4/2024.
This is the same letter which has been
Same
referred.
letter he referred.
Yes, this is not, this is only for personal hearing on the,
Yes.
on the aspect of penalty, not of vigilance officer. I, Sri so and so, please read.
Yes.
For
On 23,
personal
4,
hearing.
24, I, Mukul Kalita, office assistant, personally posted at regional office, Kokrajhar, appeared before the Honorable General Manager and Disciplinary Authority at VB at office at 12:45 p.m. for personal hearing in view of the proposed punishment
See.
against me.
It is against the proposed penalty.
Acha. The details of my submission in this proposal hearing are stated as herein below. I denied to have committed the irregularities as alleged against me by charge sheet dated so. I also stated that I am lone bread earner of my family, consisting of my wife, an old aged mother, and 2 minor sons who were wholly dependent on me for their subsistence. In case of my dismissal from the service, the entire family will be ruined.
Thereafter, you read.
Thereafter, though initially I denied the allegation, but later on, I realized that if I tell the truth, the proposed punishment of the dismissal from service might be reconsidered sympathetically by Honorable General Manager and Disciplinary Authority, so I confess my insult. This is a statement he made.
Yes,
And there is a reference in the imprint order that
this is a
Import-
statement before, in terms of what? In terms of the order dated 23/4,
23
2014.
23 is the order by which I was directed to appear for personal hearing.
Personal hearing for what? On the proposed penalty.
Personal hearing, of course, may
On
not
the
for
proposed penalty.
reappreciation.
No, 23/4 is there on the records, and actually you.
I'll show you. Please put on actually.
It may be 108 in your brief, maybe.
108. No, 108. no. Is no full of it. Full of. A department, man, I'm reading.
Yes.
A departmental inquiry was held into the charge framed against you in bank's letter charge number so and so. Observing the principles of natural justice, it appears from the proceeding of the inquiry that the reasonable opportunity was given to you for conducting your defense at the state inquiry, and you also fully participated in the inquiry. I have carefully gone through and considered the records of the inquiry, evidence, documents of the findings of the inquiry officer. I concur with the findings of the inquiry officer, and I am satisfied that on evidence recorded on the inquiry, the charge as leveled against me in the said letter of charge have been proved and established beyond doubt. After considering the facts and circumstances of the case, the gravity of the misconduct, and your first record, it has been tentatively decided by me to impose upon you the following punishment. But before I take a final decision with regard to punishment as stated above, you are hereby given an opportunity of being heard personally on 15/5/2014 at 11 a.m. at Assam Grameen Vikas Bank head office, Guwahati. Accordingly, you are advised to remain present in the state hearing on that date, time, place, and indicated above. You may, however, submit your written representation if you prefer to do so with regard to said punishment instead of appearing in person. But in that event, your written submission would reach undersigned on or before 25/2014 positively. Please note that if you neither appear personally on echo or nor submit any written representation within the stipulated time, the matter will be decided at court. So, my lord, it appears that I was asked to appear before the officer for personal hearing. And they took into consideration this particular letter. Already inquiry was conducted. All charges are found against me on the basis of material, as well as the statement you have made before the vigilance office on 2014 in terms of this court. Therefore, my lord, and it is
No,
a
15.5 was fixed for your personal hearing.
personal
not-
hearing.
Not because vigilance officer, it was before the disciplinary authority.
Yes.
Against
Because-
that, you had given, on 15.5, you had given a written submission as well as you had appeared personally.
Personal. Both. 15.5, I have and I annexure V. And in that case, I denied everything, my lord. Therefore, my lord, suddenly, my lord, in personal hearing, as it reflects that I made a confession, my lord, debiting from my last statement or last stand taken in, my lord, representation dated 15/5/14 on the same very day. And I have taken all points, how they have conducted the inquiry. And I, my lord, specifically, I contended that I am not involved. It is a perverse finding, etc., etc. The inquiry was not in conformity with the materials on record. And on the same very day, I confess. I confess. My lord, it appears to me, my lord, in between something happened.
No,
Either he was given some assurance,
No, even assuming that your confession was extracted from you,
my lord,
but you are not in a sound state of mind,
my lord,
you let us ignore that for the time being.
my lord.
But what are your grounds? Can you sustain the grounds which you have urged in support of your petition? First ground is not sustainable. Second, we'll examine, we'll have Mr. Datta's response.
My lord.
What is your pleadings on this? Your
Submission.
admission part?
Admission part,
On the admission part,
yes,
where you have stated that, yes, I have done it. What are your pleadings? Where you have stated that you were forced to make.
yes, yes, my just give me a minute. Paragraph 34. May I read, my lord?
Please,
At page 33,
yes.
possibly. The petitioner states that copy of the statement recorded by the vigilance officer in course of personal hearing on 15/5/2014 was communicated to the petitioner along with the impugned order dated 27/5/2014, and by disciplinary authority accepting it to be the basis of imposing such major penalty. But having gone through the said statement, the petitioner got totally perplexed and frustrated as to how the vigilance officer could record the petitioner at a later point of time, realized the truth and admitted the guilt on consideration that in the event of admission of his guilt by deviating from his defense reply, the disciplinary authority would take a sympathetic view and impose a major penalty. It may be noteworthy to mention that once the petitioner denied the charge, even during the course of inquiry and subsequent defense reply, there cannot be any occasion or reason for him to deviate from the defense stand and admit the guilt as reflected in the statements during his personal hearing on 15/5/2014. The said unfair approach on the part of the disciplinary authority therefore totally vitiated the legality of the impugnment. At least I have made some statement.
No, but Mr. Broadcaster,
My lord,
in the impugned order at Annexure X,
yes,
the impugned order is not based on any confession of yours.
if I may not read once again the first paragraph.
We have read.
Lordship has read, my lord. Let me one more, my lord.
Yes, please.
I read one more. Pursuant to letter dated 23/4/2014 and your personal hearing,
Yes,
response to it with regard to proposed punishment I have carefully considered your submission in the background of the charges, libel against you, inquiry proceeding, connected papers, documents, inquiry report.
Hmm.
Therefore, it is one of the consideration.
No, there is no reflection that he
Personal
could have-
hearing,
he could have clearly said that you have admitted, so there is no question of any reducing. See, in view of the facts and circumstances of the case and the gravity of the misconduct and
My lord.
considering your prayer in
yes,
respect of purpose penalty, I have again applied mind. There is no question of again applying mind if he would have gone ahead with your confession
my lord.
and have come to the conclusion the proposed penalty is commensurate, which cannot be reduced. So that has not been,
My lord,
has
if-
not played any role in the
My
mind
lord,
of the
if-
decision-making
Yes,
process.
my lord. If lordship, my lord, is otherwise inclined to, my lord, peruse this particular, my lord, annexure, there is an impugn order,
Yes.
and arrive at a conclusion that there is no any rationing.
No,
Because it was
he was
not
not-
taken into
He
consideration.
was not influenced by
Yes,
the confessional aspect.
Yes.
So we don't think that will make any material difference in our decision-making process.
since my lord, lordship wants to say, since there is no any reference,
No, and rather the tenor of the language used, employed in this impugned order,
my lord,
as well as the application of minds in those fields, like the statement, if you see in the second paragraph,
my lord,
I have again applied my mind and have come to the conclusion that the proposed penalty is commensurate and further, and it cannot be reduced. So he has,
my lord, if that aspect is excluded because of not being referred, then my lord, of course, my lord, they rely entirely on the materials.
not
as
only not referred, it doesn't
influenced.
appear that he was influenced
My-
also.
my-
Rather, he had applied his mind to all
My-
your defense and your pleadings made in the
My lord.
reply to the order or letter dated 23/4/2014.
That means they altogether ignored whatever I have submitted, whatever I have confessed.
Regarding the confession part, that has not been taken into consideration.
And lastly, my lord, number of persons were made involved, number of persons were, my lord, were charged sheeted. It is, record doesn't show what is the punishment, my lord, inflicted or imposed on others.
Where have you stated?
And it is the.
Where have you stated? There are a number of persons who are
Yes,
charged
sir.
sheeted.
My problem was that, my lord, after that I appraised your lordship, brief was missing, my lord. I got the brief. So, in spite of my best effort, my lord, I could not prepare to the extent as your lordship desired. Yes, sir.
Mr. Dutta,
But I'm just going through, I will refer it.
if needed, we'll get a reply from you after Mr. Dutta completes. Okay.
Milord, I'll just hand over the report of the disciplinary proceeding. Milord, I'll take your lordship to the charge sheet part.
Yes.
Lordship will find it at page 62. The article of charges. During the tenure of your service at banks Goalpara branch from 5/4/2001 to 27/2005 as clerk cum cashier, you were found involved in some malafide fraudulent transactions which had exposed the bank to suffer financial losses to the extent of rupees 3,85,000. Number one savings bank account was opened in the branch on 23/3/2005 in the name of Sri Nirupam Das, with his address recorded as in the village of Balatmari, Goalpar. The account number of the newly opened account was 12729.
The account holder customer Sri Nirupam Das was introduced by Sri Gunindra Medhi, an official of District Agriculture Office, Gwalpara, having his SBI account bearing number so and so, dated so and so, in the Gwalpara branch. Subsequent to Sri Medhi, the introducer denied to have introduced the said person, the identity of whom he does not know. The said account holder, that is Sri Nirupam Das, was not known to anybody in the locality, including the branch officials of Gwalpara branch at the recorded address. The account opening form, the specimen, signature card, etc. were filled in by you in your own handwriting, and you also signed as Sri Nirupam Das and related documents. Thus, with the malafide intention to deceive the bank, you committed the gross irregularities of opening fake saving account by affixing on photograph through which bank's money was shipped off. Charge sheet 3. 4 numbers of withdrawals were made in the account number so and so, amounting to rupees so and so respectively, with total amount of rupees 3,70,000. All the withdrawals instruments were written by you, as well as signed by yourself as Nirupam Das. These fraudulent exercises you had utilized one outsider who signed his name as Rupam Das and acted as bearer to receive the money from the cashier against the withdrawal. So, my lord, if your lordship look at page 86 in the cross-examination, so for these charges they have accepted me. I'll just draw your lordship's attention at page 86.
Yes.
The cross-examination of, as a lordship got that.
Yes.
Cross-examination against charge sheet number 3. The cross-examination made by defense representative Mr. Mirju Mahilari said that he is agreed with the charge sheet number 3, but all the withdrawals written by Mukul Kalita and all withdrawals passed by Islamuddin, authorized officials of the bank, and ledger entry made by Mukul Das, and cash payment paid by Samir Sengupta, and all the withdrawal is equal, which is equally responsible for above mentioned person. They want to say the charge is correct, but the 3 persons are involved. So therefore, these 3 persons are equally responsible.
Is that the meaning?
Now, my lord,
No, is that the meaning assigned?
meaning, my lord, they want to say.
Now
three
see,
persons-
this this Mirju Mohilari appears to be the defense representative.
He is the defense representative.
Defense representative. He cross-examined the only witness.
Yes,
Now, where is the scope of he agreeing?
he is saying that so far this charge is concerned, I make, that is the wording is like this, he is agreed with the
No, when
charge
the
sheet number 3.
delinquent did not adduce any statement,
He did not adduce any
neither he had adduced any evidence.
Well,
Recording of such a statement perhaps will not be proper. How a defense representative said that I am agreeable and it is recorded? He is putting a question, answers will be recorded.
no, that apart, my lord, your lordship will find the person who is involved, he did not give any evidence. Did he say that it is not my signature? The MW1 has said this is the signature. Every vouchers have been made by him. It is in-
MW1 is whom?
Beg your pardon,
Who is
the
MW1?
delinquent, my lord. He did
No,
not,
delinquent is not MW1.
no, MW1 is the witness of the bank.
Is the only witness, the
Yes.
investigation officer.
Now, he has said that all the vouchers were, my lord, written by the delinquent. Now, he never said that it is not my signature. I did not sign as Nirupam Das. So that part of the thing is nil, man, since he did not come up and say that I did not do all these things.
But he had filed written statement of defense.
No, now,
He may not adduce evidence. It's a
Yes.
quasi judicial proceeding. But he is cross-examining the witness. Who is the witness?
he has,
Only the investigation officer.
yeah,
Now, investigation officer, his initial report was in favor of the delinquent. That's a different matter. We are not too much.
it's a different thing altogether.
Now, in his examination, he makes certain statement. He is put to cross-examination. Is there a necessity for the delinquent to have his statement?
So, my lord, he has to deny that these I haven't sign all these vouchers. It's not in my.
Denial is there in the written statement.
Now, even the cross-examination, what he has said, the
Yes.
lordship may kindly see the disciplinary proceeding record. We are not required to go into other things, my lord. This the record is sufficient. The lordship may see from page 6 onward,
Of the compilation which you have given to me.
my lord.
Okay.
Page 6, MW1.
Hmm.
The question is, it is the account opening form in the name of Sri Nirupam Das, an account opened on 23/3/2005. An account was introduced by Gunendra Methi. MW1 Inquiry officer and the inquiry officer marked as ME Material Exhibit 4. Please see the documents and tell about it. It is the specimen card of the Nirupam Das dated 23/3/2005 without authenticated by the authorized officer. An MW1 gave it to inquiry officer and inquiry officer marked it to ME5. And PO, please see the documents and tell about it. MW1, it is the cash receipt voucher bearing account number so and so, deposited by Nirupam Das, signed by N Das. The amount received by S. Chakraborty. Roll number 121, state voucher, enter into ledger number so and so. Then PO, please see the documents and tell about it. MW1 is a SP check number so and so, bearing account number 1729. Ledger folio number so and so, dated so and so. Amount rupees 30,000 drawn by self, paid by the cashier. Then the next question, please see his documents and tell about it. If it is the SP check number so and so, bearing number so and so, the account number is that 12729, dated so and so, amounting rupees 1,50,000. Duly issued by account holder and that the amount received by self and give it to inquiry officer. Inquiry officer mark it exhibit 8. Then please see this document and tell about it. It is the SB check number so and so, dated so and so, amounting rupees 40,000 against SB account number so and so. Authorized officer, the amount drawn by self means the delinquent, received by bearer Rupam Das, and the check signed by N Das. The MW1 give it to the inquiry officer. Then please see the documents and tell about it. MW1, it is withdrawal slip dated 12/4/2005, amounting rupees 1,50,000, bearing account number so and so, duly ordered by authorized official of the bank, paid by cashier, received by N Das. Then the next question, please see the documents and tell about it. MW1, it is a debit transport voucher dated 8/6/2005, amounting paper of rupees 15,500. This is the transfer paper. Advised to transfer the amount to our Nijni branch, duly authorized by official of the branch, and voucher entered by Sri Mukul Kalita, but ledger folio number so and so, so and so. Inquiry officer marked as 11. Please see this document and tell about it. MW1, it is a advice number so and so, dated 8/6/2000. This is not that important. Then, my lord, voucher prepared by Mukul Kalita, exhibit 12. Please see the documents and tell about it. It is the documentary evidence, serial number 1 to 25. This is important. Are written by Mukul Kalita, Rupdara branch, under his own handwriting, duly certified by Sri Anjan Bhattakur, Senior Manager, Gwalpara, and authenticated by Chief Manager, Vigil. And it's marked as 13, Exhibit 13. Please see the documents and tell about it. Is the documentary evidence serial number 1 to 24 are written by Sri Mukul Das, OA Gwalpara branch, under his own handwriting, duly certified by Sri Anjan Bhattakur. Then it's marked as Exhibit 14. And please see the documents and tell about it. MW1, it is a declaration made by Anjan Bhattakur, Senior Manager, Gwalpara branch, advice to the investigating officer, Regional Office, Kokrajhar. Contrary to the declaration dated number 1, account opening, closed register, transfer journal, token register. These are all the registered they have referred. Then please see these and tell about it. MW1, it is a replied copy against charge sheet number so and so. Then please see the documents and tell about it. It is a opening made by Dr. Well, it is the opinion of Tilak Das, saying that's the handwriting surfacing. Then your lordship may see the cross-examination part, which is at page 11. Cross-examination of MW1. The chartered employees,
Page
page 11,
11,
number 1 chart, the CAC tell
not 11. There is no 11
at page 11, Mali.
of the compilation which you
Yes,
have
yes.
given. After 5, the proceeding adjourned, then it comes with a new page, proceeding copy for page 1.
That is, my lord, I have, possibly it will be number 1, page number 1, my lord.
Yes,
Then cross-examination is page number 2.
cross-examination, right, page 2.
The charge sheet number 1, the charge sheeted employee challenges that the authorized official open the account as the account holder is not traceable as per his address, and the introducer denied that he do not know the account holder, and he do not open, no,
Yes, yes,
he do
sure.
not sign the account opening form. MW1 clarifies that as per practice of the bank, all related papers along with the account opening form and specimen card received by the authorized official and accepted to open the account. As the authorized official was the manager of Durtara branch and passing officer of Gwalpara branch, 3 days Durtara branch and 3 days Gwalpara branch, he could not, being probably identified as his customer was gathered, as Hughes' customer was gathered in front of his table. Hence, the authorized official of the bank asked for the, this is the explanation. Then regarding second chart, the management witness number 1 clearly stated that handwriting in the account of opening form, specimen card, withdrawal check, deposit slip, etc. was written by Mukul Kalita, that is charge sheeted employee. And the management witness number 1 also stated that as per his investigation, there was no person was available in the mention of the address in the account opening form, and the photograph which was affixed account opening form was not known to anybody of that locality. The charge sheeted employee in reply MW1 stated that the account holder known to him and was introduced and
No, not introduced, this is, and was
filled up the opening form.
illiterate,
Yes,
was illiterate,
he raised the fill up
requiring,
opening form.
requiring the filling up.
Handwriting is very difficult. withdrawals, etc. Accordingly, the CEC is comprised. But whenever
Question
situation
arises, whenever question arises.
question arise and charge created him, I personally tried to find out the account holder, and I have come to know that the account holder not now is residing outside the state of Assam. So I
So he
request
took
your honor-
7 days time, it was granted.
Yes, yes.
Thereafter, it was
Then-
adjourned to 7 days. Thereafter, what happened?
Then, my lord, ultimately
Okay.
he could not produce him. Your lordship may turn to page,
Next page.
your lordship may come to page 15, my lord.
No, the pages are not numbered as yours.
It's- my lord, I'm sorry. It
Doesn't
will
matter,
be-
doesn't matter. The proceedings of held on 8/8, 8/8.
2013.
Yes,
And from there, your lordship may come to
The account opening.
proceeding at 27/8/2013. There your lordship will find cross-examination against charge sheet number 3.
27/8, yes. Process amendment, but yeah.
Cross-examination made by that defense representative said that he is agreed with the charge sheet number 3, but all the withdrawals written by Mukul Kalita and all withdrawals passed by Islamuddin Ahmed, authorized official of the bank, and ledger entry made by Mukul Das and cash payment made by Shamiruddin and so ex-cashier, and so all the withdrawals is equally responsible for above mentioned persons official. Now, cross-examination against charge sheet number 4. Defense representative said that all the advices written by Mukul Kalita, CAC, as per direction of the authorized official of Islamuddin and closed account opening form of the applicant and specimen card for the Mukul Das messenger. Now, this is all, and the charge sheet cover 5 is concerned, that is not proved, my lord. So we need not go into all that. The last, my lord, your lordship has seen that the delinquent did not wish to give any evidence. So, my lord, it is emphatically clear from the evidence on record that he is the person, my lord, he created all the vouchers. He has written in his own
But how
handwriting.
you proved it? Was the scientific officer brought to the
My lord, then
proceeding?
is the opinion of the officer who has.
Tilak Das.
Apart from that, my lord, even the MW1 has said, this is his handwriting because he is the manager. He knows his handwriting.
MW1 did not say on his own opinion. He relied on the expert opinion.
No, in the cross-examination, he has said, it is all the signatures
No,
are
no,
of
no,
his.
he is based on Tilak Das, page 5. Page 5 of the proceeding. After producing all documents by the charge sheet so and so, kindly come to page 5 of the of your compilation, this proceeding. I think the
My
third or
lord,
fourth.
in the cross-examination part, if your lordship come at page 2, even if we go to that, if your lordship see in the middle, the management witness number 1 clearly stated the handwriting in the account opening form, specimen card, withdrawal check deposit slip, etc., was written by Mukul Kalita. And the management witness number 7 also stated that as per his investigation, there is no person who is available in the mention. Now, he has specifically stated that it is written by the delinquent. On the basis of that itself, it is sufficient to say that it was all handiworks of the Mukul Kalita. Well, the expert's opinion is not required to be.
No, who has stated?
He is the, my lord, witness number one,
Who was he?
MW1.
Who was he?
He is the manager,
Most investigate.
Hari Ghosh.
He was MW Hari Ghosh, he was the investigator, senior manager. Has he has he said anything that I know his signature?
My lord, he's saying that his signature was his.
No. Has he said that I know his signature?
No, my lord, obviously he's the manager of the bank.
No. We cannot
And he's
assume.
working under him.
No, where is the necessity to send it to forensic science then?
My lord, that was the, my lord, not necessary even when
No,
he
if you
has,
have taken a step
when
to
he
send it
has
to,
proved it.
it's not proved.
And apart from that, my lord, if supposing the expert was, it is according to them, he should have been brought. He could have, my lord, filed an application to bring him. He
Oh.
also did not make any endeavor.
How you are relying upon an expired document
No,
without,
I'm saying, my lord, my first case is that MW1 has emphatically said
show us
that,
where.
my lord, let me see in the first part of the thing. At page 4, my lord, he has said, it
Yes.
is documentary evidence, serial number 1 to 24 are written by Sri Mukul Kalita of Durdara branch under his own handwriting.
Page,
Duly certified by so and so.
page.
Page 4, my
Oh, you do one thing, kindly. Junior Datta, just match the numbers because
Hello.
that bunch, the numbers are different. Don't change the numbers in the originals, change the
Right.
numbers in the photocopies.
Well,
There are discontinuation. After page number 4, there is again 1 because it's another date. That is okay. Then it will be easier to correlate.
look, I'm giving the continuation one
Don't make it the original. You make changes in your
in my,
copies. So it'll be easier. You can refer to the dates of the proceeding
right,
because this different proceeding has given different numbers. Doesn't matter.
yes. continue to.
Yes.
Effects. Your lordship, the query is that whether he has accepted any point of time that he knows he's writing.
Not accepting. He has to say that, yes,
I know he's.
yes, the statement has to be made.
My lord, in that case, my lord, can you lordship take it at 2? In the meantime, I will.
No,
go through that.
it's only a 4 or 5 pages proceeding. We don't find any statement of that
My
nature.
lord, it seems that way, my lord, I did not find, but
No, why we are repeatedly asking you that? See, you had on your own volition had gone to the opinion to seek an opinion of the expert. Having that, and the expert is not before the delinquent, and you're relying upon that. If you're relying upon an expert, that indicates that there were no competent witness inside your office who could say that, who could vouch that I know his signature and this is his signature. That is why, to rule out any difficulty,
your lordship is very correct.
you
my
send
lord.
it to expert. You could have very well asked the expert to come. There was no effort even to bring.
My lord, what happens, my lord, if the manager says, I know his signature.
Then it is good.
That is enough.
Enough.
Because if.
He could have very well said, yes.
Yes. he could
And
have-
it is very, and it is in fact very normal to assume that a manager would know the signatures. That is the
Yes.
basic thing.
Yes,
But he has to say it.
but he is required to say that.
Record. And more so when you had sent it for expert opinion.
And so for expert opinion, my lord, this is, of course, they have been deprived of cross-examination. If he is not produced,
And
Look-
I would differ with your thing. It's not his duty to call him. If you are relying upon a statement made by him somewhere else, here you are relying upon a document, an opinion, without producing him.
from apparent reading, my lord, that way, your lordship's query, I did not find exactly saying that I know his signature. Because if he knows his signature, that appeals court has the time and again has said that it is enough. But then that evidence is required to be there on the record. So therefore, my lord, what I find,
But at the same time, the charge is not a light charge. Charge is serious.
charges, my lord,
Charge
your
is
lordship has
serious.
seen.
Charge is serious.
Whether a person like him, bank can rely any confidence on him. That's the question, and rightly the dismissal order is,
Now, this amount came from whom? It was credited in the, let us assume words for the petition. There was a fictitious entry in the name of one Nirupam.
Yes.
Now,
that person is not there at all.
no, fictitious, let us assume it's fictitious. But there was credit in his accounts. Credit from where?
My lord, that is the bank money.
No, where? It has to be by some instrument, instrument or cash. You are not traced out from where the money had come. Yes, somebody had opened an account, then there were fictitious debit from the account.
Ultimately, your lordship will see the conduct. A bank official, in whatever way he's dealing, my lord, can you do that way, my lord? By
No, see,
making the-
your submission would have been very relevant if we are more or less agreed with the procedural aspect, then whether we can reduce it or anything else. Now, charges are serious, we are not doubting that. But whether it was able to be proved.
The lordship is saying what is the source.
No, what is the
No.
proof? No, even if you ignore that aspect,
That is
how
not-
have you proved the charges? Are those proved at all?
Either, my lord, your lordship will see that the fictitious account has been opened. And being a bank official, my lord, by he himself, he is pretending that he is Nirupam Das.
See,
He
no.
is signing.
No, okay, no. See, opening of a fictitious account may be one of the misconduct, but the misconduct will attain a certain degree of intensity when public money is being siphoned through that account. Now here you say that amounts were credited which were taken out by the some person and you have implicated the petitioner. The amount came from where?
Well, that is, there is no indication so far that is concerned. But then question would be, if a bank official is doing that,
No,
and
so
it is a fraud.
that is where we are fixed. If he is doing that, have you proved that he was doing that?
Well, that is that evidence is there. Only
Show
thing
us,
so
show
far-
us, show us that
So
evidence.
far, he
Better
is
we'll close it. Show us the evidence that he was,
only,
he had proved
only,
it.
only question is this, whether the bank officer has said that.
No,
was
even
a
other
whose
evidence,
signature.
even other evidence that he was involved. That is
Apart
the
from that,
allegation.
Expert's opinion is also there,
As far as he's
but
not,
they are saying
he's
the
not there.
fruits he was not produced. Well, your
They are
lordship
not
can-
saying, I am saying.
Oh, all
Court
right,
is saying.
Now,
They have not even raised this issue.
in that case, what will happen, my lord? Let us from that stage, my lord, let the expert be called and they can cross-examine from that stage. Your lordship can pass an order.
What will the, this thing, was he under suspension?
So I think.
No, he was dismissed
No, no. not
initially.
No, no. During the period of the inquiry, was he under suspension?
That, my lord, I just can't say.
Mr. Purkashta?
My lord.
During the proceeding,
Yes,
we have found that initially you were suspended.
my lord.
Now, was the suspension revoked or you continued to be under
No,
suspension?
my lord. I think my lord, suspension was ultimately converted into dismissal. Lord.
You are not answering. We are not, suspension is not converted. Suspension is not a
Suspension was,
penalty.
my lord,
I was saying that till the order of dismissal was passed, you continued to be in service, suspension or were
because
you?
they did not revoke the suspension.
Okay,
order.
that is it. You continued to
It
be in
comes to an end
suspension.
by my lord subsequent dismissal. Lord. And now one more thing, my lord.
No,
Lordship,
we can think over that we,
That's
if
the
we-
way your lordship.
if we remand it,
Yeah.
we'll ask you to maintain the order of suspension till you
My lord.
finish it within a time-bound frame
My,
by bringing in the,
my lord.
but we will give you the chance only to bring this thing,
Expert.
expert opinion.
Yeah.
You cannot reopen everything now.
No, it's not necessary also.
Expert, he'll come, he'll vouch that
Yeah.
that particular material exhibit,
That's all.
and he'll be given a chance to
Not
cross-examine.
for cross-examination. That's all.
Because opening an account in the fictitious name itself is a misconduct. Whether transactions are done thereafter will not be very material.
Right.
Why have you
So the
opened a
act-
fictitious
act
account?
committed.
My lord, I understand my lordship is absolutely right. Charge is of very serious nature. Public money, no doubt about it. Lordship will at the same time consider whether it is an act of one person or it is an act of many other persons. Because initial report says number of persons are involved. And now they have to justify, my lord, what is the action taken against others. I have made in my paragraph, my lord, paragraph 58, that no any, my lord, action was taken against others.
Were the
Even if-
other officers or personnel charge sheeted?
My lord, your lordship, I have a reply in my affidavit. Your lordship kindly see at paragraph 8.
Yes.
That in regard to the statement made in para so and so, your deponent backs state that Islamuddin Ahmed, Indian passing officer of the branch, was also proceeded against for his negligence in signing the account
Oh,
opening
He
for
was punished.
and passing of the withdrawals of Sri Nirupam Das negligent. He was inflicted punishment in commensuration to the gravity of his proved misconduct. However, it was proved in the inquiry beyond doubt that Sri Mukul Kalita was mastermind in the plot of defrauding the bank. Have you said by giving any affidavit? My lord, we have, where by taking of affidavit, my lord, we are saying that, and they are saying no punishment was given as if
We have
they are
given
the
our
bank authority.
affidavit.
And in para 10, you will also find. So for Mukul Das, his involvement has not been found.
You have not said anything in the reply, Mr. Purkaster.
My lord.
Paragraph 8 has been replied in your affidavit in reply. That too in paragraph 8, where you had made a common reply to 6, 7, 8, 9, 10 to 14.
Yes.
There is, you have not said anything. That other gentleman, Islamuddin, was.
No,
not
I'm
punished.
I'm just looking at.
I have seen it.
But in my writ petition, my lord, there is a statement
No, writ petition has been answered by their
by them.
opposition.
Now, that would be the best report, my lord. Our lordship has, my lord, indicated. Let there be, my lord, one more opportunity to cross-examine the, my lord, expert. And ultimately, if we cannot, my lord, controvert the.
Mr. Dutta, we'll balance the order. We cannot ignore the seriousness of the gravity of the offense, the allegations. At the same time, we cannot overlook the aspect of requirement of at least a semblance of proof. It may not be beyond all reasonable doubt, but at least a fair chance needs to be given.
Yes.
We will try to balance it.
Yes.
We'll pass the orders, we'll reserve it.
Well.
But we have indicated what we're going to
Yes.
pass. We'll retain your original copies.
Well.
Or if you want, you can give the, no, let us, we'll hand over this back. Third. Sri A.K. Purkaster. Learned
Right,
counsel,
yeah.
no? So and so. S. Datta, senior counsel, assisted by Subham Datta. You're Subham. Or and your name and Kolita for K. Fukan. K. Fukan. Who is K. Fukan? Full name? Okay. Okay. K. M. Fukan. Okay. K. Kolita. Hearing is concluded, judgment is reserved. Sri Datta has learned counsel has also handed over the original copies of the inquiry proceeding.
Your lordship want exhibits, that was the impact.
Not required.
Huh.
Will not pass a very elaborate order.
Well, the only thing your lordship can.
But what is your age, Mr. Purkaster? You are around 60, 59, 60, we have checked. What
Let
is
me
the
tell
age
you
of
the
superannuation? 60.
Yes.
60.
60. You complete the proceeding
Already attained his age of superannuation.
expeditiously.
My lord, that may not have any financial implication.
Which one?
My lord, if he is put into suspension, that not indicate that he is entitled to get financial.
Well, at the time of filing, he was
No,
aged
till,
about 51 years.
as a employee who was under suspension, you have been paying him.
Yes, earlier he got it. Now, in the meantime, my lord, if your lordship is sending back
59.
for
No, see,
13.
if he's surpassed the age of superannuation, the continuation suspension may not even be required.
yes, that
But
is
can you ascertain
See,
the
I
age?
think,
At the time of filing the writ petition, he was 51 years.
so then I
Now it is, my lord, now I think, my lord, 60 years. So 7 years, my lord, 59 years.
he was
9 months he is entitled,
51.
51. Writ petition at page 50.
That time he was 51.
So at the time when he was, my lord, dismissed from service,
He
is 50.
Then I think it's superannuated.
Okay.
He was dismissed from service at the age of 51 years.
That was when?
No,
That was when? Which year?
My lord, 2000, he was an imperial order 2014.
14, 10 years. Okay.
Which month?
27th May 2014.
Superannuated.
And in the event we are inclining to remand it, Mr. Purkasta,
My lord,
you should render your full cooperation. It should not be prolonged because of your lack of cooperation.
my lord.
No, it will be done within a month, but then so far financial implication, your lordship may clarify that it should not have any financial implication. Otherwise, they may say that
But dismissal, after this kind of a proceeding dismissal, any order of penalty cannot be sustained. We are setting aside dismissal, but we are giving you back. We cannot leave things on the hanging. We'll have to say something definite. Let us see how we
My lord,
protect the
you should
impost.
also take into consideration that I was directed to pay some amount, my lord. Before, my lord, coming into any conclusion that I was found guilty or charges proved against me. At the initial stage, I was directed to pay, my lord. And rest of the amount was directed to pay other, my lord, charges.
Okay.
My lord, some time may be given so that I can contact my client
Now we'll try to pass the order.
2 months at least.
Not 2 months. Okay, let's see.
Last period.
Time to bear hold on. Yes.
Otherwise, similar lordship, that petitioner was a regular government servant, lordship, working in a government of Assam. Then subsequently, lordship, that institution came to be merged with the central government, lord.
Which institution?
Lokopriya Gopinath Bodloi Regional Institute of Mental Health.
LGB?
Lokopriya Gopinath.
LGB what? LGB MHI or what?
Lordship, Lokopriya Gopinath Bodloi Regional Institute of Mental Health.
Yes, Mr.
Yes. What had happened, the petitioner before lordship is presently working as the director of LGB as Institute of Mental Health. Earlier it was Tezpur Mental Hospital. It was run by the state of Assam. Lordship knows in the syllabuses case, there are some directions were given.
Committee had come.
Subsequently, my lord, the institute was
Earlier it
taken.
was called Tezpur Health Hospital, Mental Hospital.
Mental Hospital.
Okay.
And presently, my lord, it is Lokopriya Gopinath Bodloi Institute of Mental Health.
LGIMH.
Yes. LGB
IMH.
IMH.
Okay.
Now, my lord, what had happened pursuant to the order of the Supreme Court, basically central government through NEC has taken over the hospital.
Okay.
Now, that is the background.
Yes.
Now, my lord, in the agreement, there is a particular clause which is very important. If your lordship will kindly come to page 30. 30. Clause number 6.
Yes.
all the incumbent officers and other employees of the institute shall, as from the date of commencement of this agreement, be governed by and be subject to rules set out in the Constitution and bylaws of the institute hereto as amended from time to time. All existing employees will be given choice of absorption in the new setup or reversion to the government of Assam. Now, this is important. The terms and conditions governing all employees serving and employed by the institute shall not be altered to their disadvantage. Now, what had happened, my lord? As a result, the NEC stepped into the shoes of government of Assam. There was a management committee, it's a society, that is how it is being operated. So the dispute is not with regard to that. Dispute is regarding condition of service of the petitioner, who is, my lord, presently the director, plus he is a professor. Now, what had happened, my lord? Now, when it was taken over by central government.
When
then-
was it done?
My
This
lord,
was in 1999.
yes, 99. Then, my lord, when the institute was taken over by government, then I wrote to them, kindly encadre me in the central health services.
You wanted to be absorbed.
Naturally, they did not. Now, Lordship will kindly come to that later. Please come to, my lord, page number 42. First,
42.
yes. First 41, my lord.
Okay.
Now, it is 3rd of August 2016.
Yes.
Now, this is a letter written by the petitioner to the government of India, that is the secretary. Now, please come to 3. The institute was taken over by government of India respecting the Honorable Supreme Court order in 99, along with the employees. My service was accordingly brought under government of India, India 99. Now, please come to 5. In the year 2009, post of director LGBRIMH has upgraded to the level of so-and-so. 7. I would therefore request you to kindly look into the matter and finalize my and fix my cadre in Central Health Services. So this was my prayer. I would therefore request you to finalize my cadre under CHS. Then my lord will kindly come to the next page. This is a letter by Government of India to the director. I am directed to refer to the above mentioned subject to state that Department of Expenditure, by their ID note dated stated as under, as per clause 6 of the agreement between Assam Government and Northeastern Council Secretariat, Ministry of Home Affairs, Government of Terms and Conditions of Employees, that is, employees of the state government as on the date of agreement, shall not be ordered to their disadvantage, as these employees are stated to be governed by Assam Services Pension Rule 69. It would be appropriate if pension of these employees, as per these conditions, are continued to be paid rather than applying CCS pension rule. So that means, my lord, though it was taken over by Government of India, but they would be governed by the State Services Rule, pension rule. Then please come to the next page, my lord. This is again a communication dated 10th of October. I am directed to refer to your letter dated 13/12/16 on the subject mentioned above and to convey approval for creation of pension cell at so-and-so Tezpur for disbursing pension benefit and other post-retirement benefit to the inherited employees of LGP so-and-so as per the Assam Services Pension Code. Then, my lord will kindly come to page number 45. Oh, sorry, my lord. Page 44 is important because my encadrement is refused. Page 44. I am directed to refer to the subject mentioned above and to state that the matter has been examined by CHS Division of Ministry. CHS Division has informed that proposal for encadrement of dowry into CHS is not agreed to in view of the following. So, my lord, my encadrement in this CHS was declined. Then, in the meantime, my lord, what had happened at page 45, the age of retirement of professor and above in the government of Assam was enhanced to 70 years from 65.
Page?
Page 45. Page 45. in pursuance of cabinet decision dated 18/8/22, the governor of Assam is pleased to raise the age of retirement of faculty member medical of all medical colleges of Assam under Medical Education and Research Department from 60 years to 75 with effect from the cabinet decision. Now, my lord, on one hand, they will not encadre me in CHS. They want me to continue as a state government employee. Now, state government has raised the age of superannuation. So, my lord, I should be given now. It can't be that neither I will be encadred in the CHS, nor I will be allowed to avail the benefit. So, as a result, what happened, my lord? Tomorrow, I am going to attain the age of 65 years. So, they have issued this impugn order at page 54. I am challenging this. Page 54. Now, this has been written to the Principal Secretary Health, the Government of Assam by my lord, Government of India, Ministry of Health and Family Welfare. I am reading the third para. In this connection, it is submitted that as per Constitution of the Institute, S.K. Deori is attaining the age of 65 years in July 24. Hence, he is superannuating on 31st of July 2024.
You're reading page 54.
Page 54, para number 3, Miller. Third para.
Oh, yes, yes.
In this connection, it is submitted that as per Constitution of the Institute, S.K. Deori is attaining the age of 65 years in July 24. Hence, he is superannuating on 31st of July. It is requested to release his superannuation pension, GPF and all other retirement benefits as applicable under Assam Services Pension Board. But the issue is, you will deny me encadrement in CHS and something is percolated in my lord Assam. That also you are denying me. How can you do that? That is my case, my lord. So I have a right to continue up to 7 years because the agreement says service condition will not be altered to my disadvantage. So though I was basically receiving salary from central government, but for all intent and purpose, I was governed by the state rule. So this is the issue, Mira.
So, Doctor?
Yeah, mandatory instruction is necessary.
Heard. Sri K.N. Chaudhary.
There are attending the petitioner's continuation as director, those directors posts have to be rotated every 5 years and it expires on his.
That's a different issue. That's a different issue, whether he's continued as a director or not.
The issue is that the impugned order, what I had heard, says that would attain the age of 65 years for the constitution bylaws. So he goes as the director. His continuance as a professor or as an employee of the Assam government is a separate issue. But
We'll examine when your matter comes.
that
Right
was
now,
yesterday, one matter is tomorrow.
Okay.
Now, if this interim order, if he continues the director, it will be against the constitution bylaws also.
Well, see,
Expressly, it says it is 65 years.
No,
cannot
his
continue beyond that.
continuation in director is not the issue. His continuation in
In
service of
service.
the.
The very impugned order says, by the constitutional bylaws, he goes as the
Then
director.
where does he go?
But as the professor in the Assam cadre, there is no difficulty. He continues in Assam
I'll be
cadre.
happy, Miller. I'll be happy.
But he doesn't continue as the director. Also, couldn't take care of that.
But that list is not before us. We cannot
But the
take into
constitutional
consideration.
bylaws have been on.
No, constitution bylaws have to be, you're pointing it, have it both the matters. We are not averse to your suggestion, but it has to be in a proper manner.
It has to
That list is not before us. We do not know.
The other two repetitions.
It has to be pointed out in an appropriate manner.
This constitution is under challenge and that is not being diverse before this court in this repetition is not being diverse. He has-
Okay,
That is a
okay.
different subject matter.
To top it on my lord, the learned council is representing him in his personal capacity and that capacity and he's president of the Union of India here. Right? The petitioner is being represented in the other.
Okay, we'll have both
petitions by-
your petition along with this. Don't worry. Okay. Heard. We'll make some observation, Mr. Mazumdar, regarding continuation and directorship.
Yes.
Heard Sri K.N. Chaudhary, Learned Senior Counsel, assisted by N. Gautam. For the petitioner, full stop. The petitioner is aggrieved by a communication issued by the Ministry of Health and Family Welfare, Government of India, to the Assam government, whereby it has been informed that the petitioner would be attaining 65 years of age as on in July 2024 and is to be superannuated on 31/7/2024. Full stop. It is the case of the petitioner that he is presently holding the post of Director, Lokopriya Gopinath Bodloy Regional Institute of Mental Health, which is under the control of the central government. Full stop. It is submitted that the said hospital was erstwhile known as the Tezpur Mental Hospital, which was under the state government, and pursuant to certain directions of the Honorable Supreme Court, the hospital was taken over by the central government, and in this regard, reference has also been made to the agreement of 1999. Full stop. As per clause 6, a choice of absorption, reversion was to be given to the personnel, and there was a specific clause that the terms should not be altered to the disadvantage of such personnel and NEL. The petitioner had made a request on 3/8/2016 to bring him under the Central Health Services cadre, which, however, was refused on 28/1/2020. Full stop. Attention of this court has also been drawn to various communications by the central government to clarifying that the state pension rules would govern the services. Full stop. The state government had taken a decision on 31/8/2022 to enhance the age of superannuation of faculty members in medical colleges from 65 to 70. Full stop. The grievance of the petitioner is that when his request for encadrement in the CHS has been declined, he has to be treated to be he has to be given the benefit of the notification dated 31/8/2022, and the impugned order would be in violation. Would be in contradiction. Would not be in consonance with the said notification. Full stop. Let notice be issued. Returnable on today is 30. Returnable on 16th of August. We are giving a short date. 16th August. Sri A.K. Datta, learned CGC. Learned Standing Council. LGBS only, accepts notice. No, Union of India, who is any Standing Council? CGC. Mr. Dhor, who was there some time back?
Yeah, good.
Is he there in the court? Sri K. Gogol, Learned CGC accepts notice on behalf of respondent number 1. Sri A.K. Datta, Standing Counsel, LGBRIMH accepts on behalf of respondent numbers 2 and 3.
2, 3, 5, 6,
Uh,
7.
Donor Ministry, I think, Gogol for 1, 5 and 6.
Yes,
And Datta for 7 also.
yes.
2, 3 and 7. And state government, Ardhar for respondables 4. 4.
Fine.
4, Mr. Chaudhary?
4.
4. That extra copies be served upon the learned council by tomorrow. Full stop para. Sri Chaudhary, the learned senior council prays for an interim order. Full stop. Taking into account the discussion, the facts observed, recorded above, comma, a case for interim order of case for passing an interim order is made out. Accordingly, it is directed that the impugned order dated impugned communication dated 22/7/2024 pertaining to the superannuation of the petitioner is concerned is stayed till the next date fixed. Full stop. Such stay, it is however clarified that the aforesaid stay order is only pertaining to the service of the petitioner and not confined to the post of director of the hospital in question. You're for STC. And who is for the other side?
And for some of the petitioner I appear, okay.
Okay. Yes. So you're fighting it today? Okay.
After a week, my lord.
Sri P. Nayak, learned counsel representing the ASTC, submits that the affidavit in opposition is being filed during the course of the that an affidavit is being filed during the course of the day. Put stop para. List after a week along with the said affidavit. Is there any interim thing? No.
No, ma'am, no.
Find the post of that. Not relate to the post of that.
No. It is not.
Cannot
No,
continue
we'll
with
not
that.
say relate without knowing.
So confining, allowing with the type.
Is not confining. Not confining. Not confining. They can place him anywhere else. Continue the service, but it is not confined to director. Okay.
May it
Yes.
please your honor,
Item number? Yes.
may it
What is
please
it?
your honor, may the matter be taken after some time, afterward for the time being, as my senior counsel is.
Who is your senior?
Senior counsel, advocate Paspade Court, sir. He will be doing the matter.
What is it, ma'am?
So this is against an order imposing a major penalty. And in fact, it is stay on the recovery of penalty for the last 5 odd years.
Stay on the?
Recovery of the penalty amount. But the penalty was this, that, 10 stages of the increment of basic pay that was that has been, now he's going to retire on tomorrow. This matter has been adjourned on a number of occasions. In fact, there is an order of 20th of
No,
June.
she's asking for time being.
Yeah.
Yes,
possible.
Oh,
no
okay.
difficulty with that. Only I say that this matter is
Okay,
taken up.
Yeah, he will be good.
Let him come. We'll take some other matter.
Yes.
Obliged.
Yes, Mr. Mazumdar, what is this?
My lord, there is a case of a termination from service of a
Yes,
constable
Health Department.
Yes.
Health Department.
No, I was dismissed from service from the police department. My lord.
Why health is a party?
My lord, because the inquiry depended upon a certain certificate issued by the
Okay.
doctors. Definitely. The petitioner, he had been appointed as a constable on 5/7/2009.
The tower is coming.
In very brief, what is your case without
My lord,
opening?
I remained absent.
You were a constable.
I was a constable. I took leave for 4 days. I remained absent on medical grounds. I reported back for duty. I was given a charge sheet.
How much? What was the
My lord,
duration?
the absence was around. I took leave on 17/3 and I joined back on September.
Around
April,
5
May,
months.
June, July, August. Around 5 months. I joined back. I was handed over a charge sheet on the same, show cause notice on the same day. I replied to it. After replying, my lord, I was not allowed to join my duties. I went back home. I fell sick again. I got medical doctor certificate. I again reported back for the inquiry.
Hmm.
In the inquiry, they sent my medical certificates for verification.
Okay.
In the verification, the certificates as such were not verified, but the doctors opined that such long leave periods may not be justified. That was the opinion of the board. Without giving me a copy of the opinion of the board, the inquiry officer, based on that opinion, submits his inquiry report. While giving me the inquiry report, the disciplinary authority holds that he agrees with the inquiry report and I am required to show cause as to why the penalty should not be imposed upon me. And that lawsuit was settled. And there are judgments on that effect that prior to giving me the inquiry report, there should be no framing of mind of my guilt. And so the matter goes back to the inquiry of disciplinary authority on my reinstatement. That in short will be my case. And there's another aspect of the matter. When I was not told about my termination of service, I had approached this honorable court. This honorable court held that they should take a decision on the inquiry within a fixed period. Then they come up to say that no, even before prior to filing of the repetition, I already stood defense. It was not disclosed before this honorable court that I already.
Mr. Dhar, records are there. Records of the proceedings are there.
My lord, I have filed they filed our affidavit.
The records are not there.
Records are not there, my lord. That is called.
It was called for definitely. Not called. How is it not called?
Record was not called. Only on the.
No, see, even he has, very briefly, he has indicated that there has been, there are allegations made by him on the procedure adopted in the inquiry. That certain materials, more particularly the opinion of the board that was relied upon without giving him an opportunity. That is one part, but more importantly, the second show cause notice was a mere formality. You had already concurred your mind with the findings and you had given him an opportunity only on the aspect of penalty, which on that count matter has to be remanded back. That will not amount to an effective opportunity. First part, we may not say anything. Second part, we have to say something. Since it is a pleaded case, in many of the cases, grounds are available, but it's not taken. We will not go on advising the parties unless a case of gross illegality is there. If we find that charges are very serious, this point not taken, we are not advising. Let us see the second show cause notice.
Page 43.
4-3.
43, my lord. Now notice that it's 6/5/2014.
Yes.
To so and so subject second so cause notice reference DP number 9 of 2030. You are hereby informed that the officer appointed to inquire into the charge frame against you has submitted his report. A copy of the inquiry or report of the inquiry officer, including connected paper, is enclosed. On careful consideration of the report and on perusal of the record and having regard to the evidence and circumstances appearing in the case, the undersigned agrees with the findings of the inquiry officer and hold the charges to be proved.
This part you needs to, it needs to, for you or your office, to educate them. It's been going on, same thing, and only on technicalities we interfere. Charges may be of serious nature. In all cases, if you go on interfering because of this, doesn't, it may not be in the interest of public service. You should be at least that much. You simply forward it. This is the inquiry report. What you have got to say?
Post 2016-17, my lord, they have been educated. This is 2014.
No, recent so-called notices I have seen. We are not saying anything too much because the points have not been raised. There is no requirement to hear him on the quantum of or what penalty you are going to impose. But there is definitely a requirement, mandatory in nature, to give him an opportunity to convince the disciplinary authority to come to a finding not in consonance with the findings against the delinquent held by the inquiry officer. That is the law. From this stage, we won't say anything about the charges. From this stage, you consider.
Page, my lord, again.
From this stage. What do you expect? What is your age, Mr. Majumdar?
My lord, he is now filing of the petition.
He was 32, my lord. In
5
20,
years, 137.
What is the superannuation? 60, same.
19. Convenience, there was an order which was passed on the same.
only this page 43,
43 status.
Okay.
There are 24 would be relevant there. If lordship is interfering only on that ground, there are 24. There are 24 is there.
2021 onwards.
Yes, madam.
311, then Ramzan Khan, we have
Yes,
quoted in
lordship has discussed that.
ECIL
And
Babulal.
the relief that has been given to this particular petitioner was at page 30, para 32 and 33. However, in my case, the petitioner was never placed under suspension. In this case, since he was under suspension, notional benefit.
Suspension, he's under suspension. He was
No, I was not placed under suspension. I was simply not allowed to join even when I went to receive the.
Okay, that is a different rule. Okay. An order dated, please have your seat. dated 12/5/2014 of passed in a disciplinary proceeding by which the petitioner was removed from service is the subject matter of challenge in this petition filed under Article 226 of the Constitution of India. Full stop. The challenge, the grounds of challenge is both on the merits of the charges as well as the procedure adopted in the disciplinary proceeding. Full stop, para. Before going to the issue which has arisen for determination, comma, it would be convenient if the facts of the case are narrated in brief. Para. The petitioner was appointed as a constable in the 16th Assam Police within bracket IR Battalion with effect from 5/7/2009. Full stop. The petitioner was transferred and was last posted in the district of Karimganj. Full stop. On the allegation of unauthorized absence / overstay of leave, comma, a disciplinary proceeding was initiated against the petitioner. Full stop. It is the specific case of the petitioner that certain documents, certain medical certificates which were relied upon by the petitioner were sent for verification. And on such verification, comma, no manipulation was found. Full stop. However, the opinion of the board was relied upon, by which it was opined that the ailment noted was not sufficient for unauthorized absence or overstay in leave. Full stop. It is the case of the petitioner that the proceeding was not brought to a logical conclusion, and yet he was not allowed to join his services. Full stop. The petitioner had accordingly filed WPC 5282 of 2015 with a direction to for a prayer for completion of DP 9 of 2013, which was also followed by filing of contempt case number contempt case 3 of 2018. Full stop. However, comma, during dependency of the contempt case, comma, the impugned order of removal of service dated 12/5/2014 was produced. Full stop. Accordingly, the present application has been filed challenging the same. Full stop. Para. I have heard Sri R. Mazumdar, learned counsel for the petitioner. Full stop. I have also heard Sri R. Dhar, learned state counsel, who has also filed affidavit. Where is your affidavit? It's not here. Who has also filed affidavit? Mr. Dhar. In your case, Mr. Mazumdar, affidavit filed or not?
Fine, my lord. My lord, record number 7.
It was fine.
Mr. Dhar, give a slip to it will be called from the registry. In the meantime, you give your copy. Was it served upon you or not?
But even the affidavit in opposition is not.
Have you filed?
Yeah,
So 15. So
You assume that it
I
was
agree,
filed.
my lord.
I think it was filed. Who has also key? Who has also? Affidavit through the respond number, affidavit in opposition, through the respond number 7. Full stop. Para. Sri Mazumdar, the learned counsel for the petitioner has submitted that firstly, the allegations were not very grave in nature, and the petitioner had bona fide reasons for not being able to rejoin his services after expiry of the leave period. Full stop. It is also submitted that at no point of time the petitioner was declared as a deserter, and he on his own volition had gone to join, which was declined. Full stop. He has highlighted the aspect that the disciplinary authority, that that in the disciplinary proceeding, reliance has been taken on the opinion of the medical board without the materials being furnished to him, by which the petitioner had suffered grave prejudice in safeguarding his interest. Full stop. Para. The learned counsel has also submitted that notwithstanding his grounds of challenge on the merits of the charge and the procedure adopted in the inquiry, there is a gross failure of justice as well as prejudice caused by the action of the disciplinary authority while issuing the second show cause notice. Full stop. By referring to the second show cause notice dated 6/5/2014, the learned counsel has submitted that while the report of the inquiry was forwarded to the petitioner to have his views, the disciplinary authority had already come to a finding of agreement with the views of the inquiry officer. Full stop. In fact, the learned counsel submits that in fact, by the said notice, the disciplinary authority had also reached a tentative finding to impose the penalty of removal from service. Full stop. It is submitted that while there is no requirement to seek the views of a delinquent on the nature of the penalties which is proposed to be imposed after the 42nd Amendment of the Constitution of India, the requirement to give the delinquent an opportunity to represent against the report of the inquiry officer is mandatory in nature. Full stop. In this connection, comma, in this connection, comma, the learned counsel has referred to the case of, to the following cases, ইয়াতে লিখিবা ইয়াৰ পৰা বাবুলাল, এটা আছে বাবুলাল, লিখি থৈ দিয়া বাবুলাল, তাৰপিছত লিখিবা ৰামজান খান, ইয়াৰ পৰা আছে আৰু MDECIL, ঠিক আছে। It is submitted that the furnishing of the copy of the inquiry report is necessary to ensure that adequate safeguard is given to a delinquent facing a disciplinary proceeding. Full stop. Para. Per contra, comma. 3. Dhar, the learned State Council has submitted that the petitioner was a member of a disciplined force and overstay of leave is a serious offense. Full stop. By justifying the penalty imposed, comma, the learned State Council has submitted that even during the pendency of the proceeding, comma, the petitioner was again absent, and thereby he can be deemed to be a habitual absentee. Full stop. It is submitted that the police force cannot afford to have a member who is not disciplined and who is not present in the duties. And such absence was without any authority of law. Full stop. Para. The rival submissions have been duly considered. Full stop. The grounds of challenge, comma, as indicated above, are mainly on 2 counts. Firstly, on the merits of the charges and the procedure adopted in the inquiry. Full stop. The second ground is the procedure adopted by the disciplinary authority after completion of the inquiry. Full stop. Without even going to the first ground, which involves the merits of the charges, by taking into consideration that the role played by a court in exercise of powers under 226 while examining disciplinary proceeding is a secondary role. And secondary role, full stop. The duty of this court is only to oversee whether the proceeding was held in consonance with the principles of natural justice and whether proper safeguard was given to the delinquent to defend himself. Full stop. This court, on the second ground of challenge, has noticed that while the inquiry report was forwarded by the communication dated, write the second show cause notice dated 6/5/2014, comma, the disciplinary authority had reached a conclusion that he agrees with the findings of the inquiry officer and held the charges to be proved. Full stop. The response was sought for only on the proposed penalty, which was contemplated as removal from service. Para. The requirement of seeking a response on the proposed penalty is not a mandatory requirement after the 42nd Amendment of the Constitution of India. Full stop. However, comma, such requirement is mandatory so far as the aspect of seeking the response of a delinquent on the findings by an inquiry officer before the disciplinary authority takes a call on such findings. Full stop. It is incumbent upon the disciplinary authority that before he comes to a finding, comma, he is required to take into consideration the response, comma, if any, by the delinquent on the findings which are against the delinquent in the inquiry. Full stop. Para. Into paragraph 21, Deepa. Paragraph 21, paragraph 22. 22. 24. 26. The 6. 26, 31 or এখানে লিখে 31 or 31 এখানে লিখে second না লিখে হ্যাঁ considering the nature of the charges either by the they can look at 31 32 31 এখানে লিখে 32 okay we are maintaining the same observation made. The resultantly, the petitioner is directed to be reinstated in service. However, taking into consideration, in other cases, we have said seriousness, we have said nature of the charges. Authorities, if so advised, may proceed with the stage of issuing the second show cause notice against the notarized strictly in accordance with it.
In case they reinstate me, my lord, then the last part of para 33, my lord, would be necessary.
33.
Para 33, barring the substance allowance part and the suspension part, the other part.
You are not suspended.
I was never suspended.
There's no question
So
of
then they would only reinstate me and give me the notional benefits till they conclude the proceedings.
That on the that would not be entitled to any because yes, it will.
Last, it is, however,
Yes,
On
it
which-
is Harbour, yes, correct.
That part.
33 last part, 34 লাগিব, 35 লাগিব. 34, 35, মোক দেখুৱাই ল'বা. Okay.
I'm deeply obliged. I was telling my friend here, this was the shortest case I have done in quite some time.
Shortest case, but not very short orders.
Well, obliged, my lord.
Yes, Mr. Ganguly? Some matter? Okay.
Next item.
And AGV and that matter, bank matter?
That is, that was item 11.
Okay, what is your Mr. Sharma? 13. Who is for the other side? Again,
I'm in there.
you're for which bank? AGV and again,
Very busy day for ATP, my lord.
many matters.
Anyway.
One we have disposed of. Not disposed of, CAV, but we'll be disposing of. Yes,
This matter, my lord, relates to non-payment of some consequential benefit after imposition of penalty. My lord, initially, my lord, lordship may kindly see, the petitioner was appointed.
yes, what are the facts?
My lord, the petitioner was appointed on 11/11/1982
11/11/1982
as my lord field supervisor.
Yes,
Annexure A, my lord, page 16 is the order of appointment matter.
page,
Page 16, 1/6. This is a type copy, and the original copy I have annexed as page 18 matter.
yes,
With due reference to your application dated 7/1/52 for the post of field supervisor.
okay,
and
doesn't
sub-
require, doesn't matter.
My
Is it-
lord,
is it
why I am
relevant?
pointing out, my lord, because my lord, earlier, he was working in the same bank
Okay,
and in the clerical case.
hmm,
My lord, he was subsequently appointed pursuant to the selection and directly recruited to the, officer-
where do you get that fact?
my lord, this is the appointment letter itself, my,
No, you said earlier you were in clerical grade.
my lord, that I have not mentioned herein, but because, my lord, there are some other round of litigations. My lord, this is not relevant and that point has not been taken.
No,
now, my-
then why are you emphasizing on that if it is
Even-
not relevant?
Even, my lord, that may be, my lord, good. That is why, my lord, I have initially pointed out this thing. Then your lordship may kindly see. Annexure B, page 19. I'll make it short, my lord, because of, my lord, the relevant issue to decide, my lord.
Yes, please.
Because there are some other fact which is not relevant here. In response to our letter number so and so dated 5/8/2003, the undersigned received your statement dated 11/8/2003,
Where
where,
are you reading?
my lord, page 19,
19.
Fine.
19 is what?
annexure B.
What is this?
My lord, this is the, my lord, penalty which was imposed earlier.
Earlier there was a proceeding.
Proceeding.
Okay,
When it finally decided to reinstate you in the bank service in the initial stage of clerical case. That was the
in
penalty.
response to received and decide to reinstate, no? This is 29/8.
29/8.
Yes,
Against that, there was an appeal. Appeal was also rejected. Page 20 is the order passed by the appeal court.
hmm. Yes.
Then, my lord, the petitioner preferred a writ petition. Page 21 is the judgment. On two grounds, my lord, the penalty has been challenged. One is, my lord, non-furnishing of the inquiry report. And secondly, my lord, he cannot be imposed a penalty to reduction in rank where he was not initially appointed. That was the two grounds of challenge in this writ.
Okay.
Page 21 is the judgment, my lord. Relevant portion, your lordship may kindly see. Page 24, paragraph 6.
Twenty-six.
Page 24, my lord. Paragraph
24.
6 of the judgment.
Yes.
Mr. Sharma, learned counsel for the petitioner submitted the punishment for dismissal from the post of field supervisor is disappropriate to the charge leveled against him. The punishment as per the review made by the board of directors reinstating him in the post of clerical grade is not tenable inasmuch as the respondent bank board directors did not consider the entire case of the petitioner on the basis of the service rendered by him. It is further submitted by Mr. Sharma, learned counsel for the petitioner, that the inquiry report was not furnished to him and the dismissal order was passed to him on 5/8/2003 without furnishing the same, which is not permissible under the law. Even till that the inquiry report has not been furnished to the petitioner, which has caused prejudice to him, and as such, both the dismissal order dated 5/8/2003 and the reinstatement order in lower rank dated 29/8/2003 are bad in law and the same are liable to be quashed. Accordingly, the Honorable Court set aside and quashed the Buddha orders, my lord.
Okay. Thereafter.
Paragraph 10,
Yes, we have read.
by which, my lord, the Honorable Court set aside and quashed the. Then your lordship may kindly see the subsequent order
Yes.
in compliance of the judgment of this Honorable Court, page 27 and 30.
Yes.
Dated 26/5/2010.
Hmm.
Second paragraph onward. On receipt of the inquiry report, the then chairman of disciplinary
Yes.
affairs of the bank proposed to inflict punishment of dismissal upon you and also advised to submit comment on the extent of punishment. Accordingly, you had sent your submission to the then
Yeah,
chairman.
that we have read. Come to the last paragraph.
My
You
lord.
reinstated.
Reinstated, but some conditions. Second page, my lord, 27A. I'm aggrieved now by the clause 1 of this reinstatement order. Page 27A.
Mhm.
Your reinstatement as officer, JMC Scale 1, will be effective from 1/9/2003, effective date of previous punishment, with minimum initial scale of rupees so and so plus notional increment payable between 1/9/2004 to 1/9/2009. Consequently, your present basic pay shall stand at this time. Then, my lord, clause 4. No arrear salary shall be payable during the period of service as clerk cum cashier from 1/9/2003 to 25/5/2010.
Hmm.
My lord, my humble submission, my lord, since the Honorable Court has set aside and passed the order of penalty imposed earlier, by which, my lord, the petitioner was, my lord, service was reduction in rank from officer to, my lord, clerical grade, that has been satisfied. And in fact, this is not permissible under the law to reinstate a person in which, my lord, he was not initially recruited. It is not permissible as per the various judgment of this Honorable Court. My lord, then, my lord, he is entitled to get the benefit of salary difference from clerical gate to my lord officer gate, that has been denied. That denial is not permissible. That is the case of the petitioner. Thereafter, my lord, several representations have been preferred by the petitioner for review of this order. Finally, my lord, after several communications, the appellate authority passed the same order at page 43. I have skipped the representation and appeals. It come to the page 43 order, which has been passed by the appellate authority.
Please read.
Page 43, Annexure M.
Yes, please read.
Well, with reference to your above mentioned letter addressed to the chairman and disciplinary authority, the undersigned has been directed to inform you that competent authority has carefully gone through the judgment dated 25/8/2008 against your writ petition number 228 of 2005 before the Guwahati High Court. Records of inquiry, day-to-day proceedings, evidence adduced, brief of both sides, finding of inquiry officer and your submission therein, and found that the order passed by the chairman and disciplinary authority by letter number so-and-so dated 26/5/2010 is just and appropriate. Hence, your appeal dated 21/11/2019 for payment of arrears salary with effect from 1/9/2003 to 25/9/2010 during the period of your service as clerk cum cashier cannot be considered. My lord. This is the facts of the case, my lord. My lord, since my lord, the earlier occasion, this honorable court set aside and quashed the order of penalty which has been imposed by the disciplinary authority, my lord, on two grounds, my lord. One, for my lord, the reduction in rank is not permissible. Secondly, my lord, copy of the inquiry report is not furnished to the petitioner. My lord, they cannot inflict a penalty which has been imposed subsequently. My lord, taking into consideration the earlier occasion that he was, my lord, reduced in the post to the clerical post, and for which, my lord, the differential amount of salary, my lord, that is clerk cum cashier and the officer. My lord, at the time of my lord imposing, my lord, initiating the departmental proceeding, he was working as a manager.
But during that period of reduction, when it was set aside,
Right.
you had worked as a clerk.
Yes, but that was, my lord, wrong. Because, my lord, it was not permissible under the law to reduce in rank in which,
But you
my lord,
did-
he was not
no, no.
initially appointed.
You're correct in contending that it was wrong. It was held to be wrong.
Right.
But you had not worked in a higher post.
My lord, that was not permitted to perform the duty of a officer by the authority.
No, will
It
you
is
be
not
an-
my fault, my lord. It is
Understood.
the fault of the authority.
But will you be entitled to the back wages?
Yes, my lord. Definitely, my lord. Since, my lord,
You may be entitled to a proper fitment that in this period you would have attained increment or whatever in the fitment, proper fitment. But back wages,
back wages, because, my lord, for, my lord, the fault of the authority, my lord, they have imposed a penalty which cannot be imposed.
no, that was the consideration before the court. Court had interfered in your favor.
Right.
Now you have been, it has been held that you could not have been reinstated as a clerk. But it's a fact that you worked as a clerk for such and such period.
Right.
Now, you should have the reduction could not have been in a category where you are not appointed.
Right.
It should be in the same category,
Right.
wherever is available. Now your appointment is field supervisor. Earlier it was a clerk. That's a different aspect. Now, for the period which you have not appointed, you are not worked,
Right.
will you be entitled to the salaries?
Yes, my lord, if, my lord, it is for the fault of the department, there is no fault on the part of the, my lord, employee. Definitely, my lord, employee is entitled. My lord, that has been said in the Naidar Singh's judgment reported in 1988 4 SCC, my lord.
1988
4
SCC.
4 SCC 170.
Paragraph.
Paragraph 13 and 25.
Name.
Naidar Singh versus Union of India and others.
Like.
NYAR. Lordship, may I provide a copy of
Yes.
this?
Paragraph.
Paragraph 13,
13 and
13 and my lord 25.
no, 13 is on the first aspect,
My lord.
which has
Okay.
already been. What about the back wages?
My lord. They are not specifically said, my lord, back wages. My lord,
No, there will be some maybe some judgment where not because of the fault of the personnel, you have been made to serve
my lord.
in a post which is lower
Then,
than.
my lord, on that aspect, my lord, one judgment, my lord. Two 2007, 7 SCC. Regarding, my lord, non-applicability of, my lord, no work, no pay. That is, my lord, that, my lord, may work in this purpose also, my lord. 2007, 7 SPC 689.
689. Para.
Paragraph 34.
Name.
Name of the person, Commissioner of Karnataka Housing Board. Versus C. Modaya.
No. Have a copy?
I don't have a copy. It is a small paragraph, my lord. I may furnish it.
$34.
34.
Here, mandamus as such was not given. In fact, the first line says, we are conscious and mindful that even in absence of a statutory provision, normal rule is no work, no pay. In appropriate cases,
Right.
you have to make out a case.
Because, my lord,
That is the only point.
my lord, my humble submission, my lord, the circumstances of the cases, because of, my lord, referring the case of Ramzan Khan, my lord, the imposition of penalty has been set aside and quashed. If the state penalty has been set aside and quashed, my lord, Then, my lord, the consequential benefits pursuant to the, my lord, antecedent was of the earlier imposition of
Consequential
penalty.
benefit would be notional benefits, fitment, proper increment, whatever you have earned. But for post where you have not worked, and this is on a better footing. There are cases where persons have been dismissed from service,
Right.
reinstated. But normally, to grant back wages, you have to make out an extreme case that there was no charge at all. Here, the penalty was imposed.
Right.
On the grounds of Ramzan Khan as well as on the ground as held by Nadir.
Right.
That if you are direct recruit, your reduction in pay, reduction in post cannot be to such a post which is not within the cadre. Here you are appointed as field officer, field supervisor. We have to reckon that this is your indirect recruitment. Earlier you are working as clerk, that is becoming irrelevant. Then reduction of rank could come only in the cadre of field office, field supervisor, anything below field supervisor, which may be the first post in the direct recruiting.
Right.
That we have understood, but as we have just said that even in a case of reinstatement after dismissal, automatic back wages will not come unless you make it a case that the charges were itself non-existing or it was initiated with mala fide intention. There is nothing against you, but still done. Mr. Have you applied your mind for back wages?
Lordship, this case, my lord, the.
See, there are decisions.
Yes.
Sharma has not shown, but there are decisions that at times discretion is granted upon you to grant maybe for 25% or 50%, whatever.
Yes.
Even in labor laws,
Good.
while reinstatement is directed under exercise of 11A,
Good.
then also.
Lordship, the order of appointment when he was reinstated, that is of 26/5/2010, Lordship has seen that.
Yes,
And
yes,
there
yes.
will be two basic conditions. One is that he will not claim the arrear salary. Arrear salary here is the difference in salary between the clerical and the officer.
Right, right.
But all other benefits, including the six notional increments, all have been given to him.
Page?
That is the reinstatement order, my lord, 27, page 27. It is dated 26/5/2010.
Page 27, yes, we have seen.
This condition, my lord, condition number 1. Your reinstatement as officer JMT scale 1 will be effective from 1/9/2003. That is effective date of previous punishment with minimum initial scale of so and so plus 6 notional increments payable between 1/9/2004 to 1/9/2009. Consequently, your present basic pay shall stand at so and so. Condition number 3, your next annual increment will fall due on so and so. No arrear salary shall be payable during the period of service as clerk cum cashier. That is from 1/9/2003 to 25/5/2010. Well, all the notional increments he will be getting, he has got in the officers. Now he is only claiming that difference in salary between the salary of an officer and the salary of the clerical cadre where he was doing.
The writ petition, earlier writ petition was allowed when?
That was, my lord, 2008. The order is dated 25/8/2008.
25/8.
Yes, 25/8/2008.
Then at least from 2008 to your order of 26/5/2010, 2 years, what did you do?
So that is neither indicated in the writ petition nor in the reply that was
No,
previously filed.
that is a matter of fact.
No, what
which
has happened
reveals-
in this case is that the when a single judge left it up to the bank to take up the proceedings again. So considering the records and considering the submissions of the writ petitioner, the board ultimately decided that he should be reinstated.
That is it,
But
no.
it's took a sympathetic view, my lord, we are.
But that is
we are
after
not-
2 years.
That is almost up to 2 years.
See, let us read again paragraph 10 at page 25.
Yes, my lord, if I may read.
Having
I
found the
that
inquiry report was not furnished to the inquiry, this is Ramzan Khan.
Yes.
Then I find that the impugned
Impugned
orders
dated 5/8/2003 and
Yes, yes, bad in law and same
29/8/2003
liable
and
to-
in law, and the same are liable to be quashed, which I hereby do. However, I leave it with the wisdom and domain of the respondent bank to complete the inquiry from the stage where they have stopped, if so advised. If such de novo inquiry is initiated against the petitioner, the same should be completed.
you did not do. You did not carry on.
No,
carry
no
on.
inquiry.
This and liberty has become futile, odious.
And the time limit was also set, but anyway, Malad, 26/5/2010, Malad, is the order that he is now seeks to back out of. So he, after this order, worked from 2010 to 2019, and then he superannuated. So, and the representations were also filed in 2010, 2011. Now, Malad, I wish to place certain judgments of coordinate benches of this court based on the division bench judgment of this court, which, my lord, a claim for arrear salary filed after this long, my lord, is barred by the latches and limitation.
But he has shown an appellate order of rejection. That was what we are thinking.
Lord.
What made you come after 10 years?
Yes.
But
That order, my lord, if your lordship.
Mr. Sharma has shown an order of 23/12/2019 at page 43. That is the question which we are about to ask.
Yes, but now, my lord, if the appellate order of rejection is started, then, my lord, the question is, can subsequent representations, my lord, always can give rise to a new cause of action? Ultimately,
no.
the claim for salary.
No. The rejection is not on the grounds of limit that we are not looking into. You have come after so many steps. You have applied your mind.
Lord. So that is why, my
If
lord.
the appeal was not even addressed, matter would have been on different footing. You are not required in law to apply your mind in an appeal filed after so long.
Punishing for a good deed, my lord. That because my lord, ultimately, my lord, the fact is that essentially he is challenging the condition in the order of 26/5/2010. My lord, lordship, he has taken advantage of that order of 26/5/2010. He worked with the bank from 2010 to 2019 when he superannuated, and again he woke up in 2019 and said that please give me the arrear in salary. I mean, Lord, even in the judgment of that Naidar Singh, which my learned senior friend has cited, that paragraph 13 clearly says that the difference in salary will not be paid.
When was the issue raised before the appellate authority?
Which is-
The
Well,
appellate,
the representations he started giving in
28/6/2010.
Yes, just a month, within a month of that order. But that order has not been put to challenge, my lord, in any proceeding during this time. From
Which one?
2010 to 2020, when he was in the service of the bank, he did not put this challenge order to challenge in any.
Disposed of in 2019.
Your appeal you can file anytime, but the question is whether by filing a subsequent belated.
no, when was the appeal filed?
Look, this appeal, I find that
Is it on 21?
2010 and 2011.
No. Was it on 21/11/2019?
The appellate order does not.
No, appellate
No,
authority.
there is a letter, my lord,
Yes,
which
what is this?
says your
Is
letter
it-
dated 21/11/2019.
19.
Yes.
Is it a letter or reminder or is it the appeal?
Well, this by the order.
If it's an appeal, we may have a different slight view. But if it's a reminder to dispose of the appeal,
This cannot be treated as an appeal in law, because that appeal has to be filed. I can place the regulations of the bank. That appeal has to be filed within 45 days of the order impugned.
no,
I can place that.
Mr. Ganguly, you have neither Mr. Sharma has addressed nor you have pointed out. You see who has issued this letter.
Sure.
It has been contended this is an appeal.
Sure.
Who has issued the letter?
But my lord, this
Can a
order-
general manager write anything above the chairman and disciplinary authority?
No, actually, it cannot.
Is this an appeal?
My lord, there is no appeal. It is only referred to as a letter.
Letter.
Letter of 21/11/2009. So this
Not an
cannot be,
appeal.
my lord. This cannot revive the cause of action which
It's
has
not an appeal. A general manager cannot superride or the original order is of the chairman. It has to be by the board.
Board has to be good. Has to be published.
Nothing less than the board.
And that appeal, my lord, has to be filed within 45 days. And there is no provision for condonation, etc.
This is not an appeal actually.
This is not an appeal, my lord. That is why it is a written letter. And the petitioner's representations, lordship finds from the record that these were rejected in 2010 and 2011, saying that no, we have taken a decision, you work. And he did work without protest between 2011 and 2019 when he retired. Then he woke up in 2019 and he said that, oh, please give me the salary. Even in Nadir Singh's case, my lordship finds that page, that judgment which my learned senior friend has given. But you will find the lordship for a moment takes up Nadir Singh's case.
Yes.
So I may just read out the operative for this in the first of the appeals. Lordship, have it, please? In the first of the appeals, the appellant Nadir Singh has, after the period of the reduction in rank, has spent itself out, been restored to the original position it would therefore be sufficient to set aside the penalty imposed on him and direct that the period of service in the PG number so and so be treated as a service in the post held by him prior to imposition of the penalty, subject to the condition, however, that the appellant shall not be entitled to any difference of salary for and during the period of reduction. In view of this, we think that the proceedings taken against him should come to an end, and there is no need to remit the matter to the disciplinary authority for selection and imposition of a fresh penalty. In the next paragraph also, my lord, in the case of so and so, the penalty of reduction in rank is set aside, which shall be restored to the post she held before the imposition of the penalty. However, for the period, if any, served by him in the lower post pursuant to the penalty imposed. on him.
Mr. Ganguly,
Good.
for the entire period, we are not even thinking.
Good.
But from the period of 25/8/2008 till 26th of May 2010, can something be done?
My lord, that claim would also be barred, my lord, totally barred by laches. That has been held, my lord, after Tarsem Singh's judgment, which lordships are aware of. I have still placed that judgment. Coordinate bench judgments of this court, my lord. I have placed two. There are so many, but I have placed just two.
Tarsem, you are placing for what purpose?
My lord, these are that the claim for arrears of salary, my lord, are barred. There is in fact a division bench judgment. I could not trace it out. If I may read, my lordship have the judgment in WPC 60 of 2017. Justice Pathak judgment, dated 3/5/2009.
Yes.
But if I may read this part, yes, the bottom, yes, 7. Moreover, the claim of the petitioner for his arrear salary was for the period from 1/8/1998 to 28/2/1998.
No, there are judgments of Justice Goel, I think, in a division bench, holding that
think that is-
arrear
that-
salary
Harendra
is
Nath,
after.
That is cited, Mullah, but I could not trace it out. Harendra Chandra Nath versus State of Tripura. 2013 2 GLT 1094.
No, I think this is not a Tripura case, I think. Assam,
That time, Mullah, Tripura.
Assam.
But in this division bench judgment, Mullah, it is clearly specified. No right to recover the arrears beyond 3 years from the date of
Oh,
filing.
you're right, 2013, okay, Tripura was. But I think it was a principal bench judgment.
Yes. At the
Maybe
time, Mullah,
Tripura case division bench, I think this is a division bench. Yes,
at that
division.
time, Mullah, Tripura was still under
Yes,
the
yes,
jurisdiction of this.
2013.
And Mullah,
Eitu Pura Jabo neki?
Justice Pathak has relied upon Tarsem Singh also. The High Court will restrict the consequential relief relating to arrears normally to a period of 3 years prior to the date of filing of the writ petition. It is also settled that the monetary.
2013 2 GLT mildly I have get 2 GLT 1094 by Harendra Chandra Nath versus State of Tripura. There is Viplab. Itu আজ ইয়াতে পোৱা যাব নেকি এখন নাথাকে নেকি ক'ত থাকে গুগলত থাকিব পাৰে ইণ্ডিয়া কানুন নাই নহয় এনেই নামটো মাৰিলে হৰেন্দ্ৰ চন্দ্ৰ নাথ the GLT তাতে বাৰু আছে এনেই you could not look at the GLT
No, I could not.
why
Let me make an effort. In this order of
what has been said in Tarsem?
Tarsem also, Tarsem, para 4. I'm sorry, para 5.
Para 5.
Para 5. Primary 2. To summarize, normally a belated service related claim would be rejected on the ground of delay and latches, where remedy is sought by filing a writ petition, or limitation where remedy is sought by an application to the district tribunal. One of the exceptions to the said rule is cases relating to a continuing wrong. Where a service-related claim is based on a continuing wrong, relief can be granted even if there is a long delay in seeking remedy with reference to the date on which the continuing wrong commenced. If such continuing wrong creates a continuing source of injury, but there is an exception to the exception. If the grievance is in respect of any order or administrative decision which related to or affect several others also, and if the reopening of the issue would affect the settled rights of third parties, then the claim will not be entertained. For example, if the issue leads to payment or refixation of pay or pension, relief may be granted in spite of delay, as it does not affect the rights of third parties. But if the claim involved issues relating to seniority, promotion, etc., affecting others, delay would render the claim stale. Doctrine of latches or limitation will be applied. Insofar as the consequential relief of recovery of arrears for a past period, the principles relating to recurring successive wrongs will apply. As a consequence, high courts will restrict the consequential relief relating to arrears normally for a period of 3 years prior to the date of filing of the writ petition. In this case, delay of 16 years would affect the consequential claim of arrears. High Court was not justified with directing payment of arrears dating to 16 years, and that too with interest. It ought to have restricted the relief relating to arrears to only 3 years before the date of writ petition, or from the date of demand to date of writ petition, whichever was lesser. It ought not to have granted arrears, interest on arrears in such circumstances. Look, this was followed by Justice Pathak in the order of this WPC 60 of 2007, Bhadrakanta Sharma versus State of Assam and others. And if your lordship has the second page, page 2,
Yes, we have seen that.
the monetary claim. So in that case also, my lord, the arrears of salary were claimed, my lord. The writ petition was filed on 3/1/2017, and the arrears were claimed, my lords, from up to 2003. And it has been observed that it is much beyond the period of 3 years preceding the date of filing of the same. For the reasons above, the claim of the petitioner in this writ petition for grant of his
Mr. Ganguly, the context of the courts directing, rejecting the claim for for the relief in those cases were a claim per se for arrear salaries without any order of reinstatement. Here is slightly different. It is not that arrears were not paid, he was sleeping over the rights. Salaries were not paid, he was sleeping over the rights, then after 10 years he comes up. Here, it was a case of interference by the court, then only he was reinstated.
But in
So
in
there
fact, my lord,
would be a fundamental difference in facts, but the principle as such would
Lord,
be there.
my submission remains that there is, my lord, because ultimately, my lord, the claim, the order that he is challenging, the condition is of the order of 26/5/2010, which reinstated him, because the court did not, my lord, reinstate him as such. The court said that, yes, the
No, no.
inquiry is set aside,
Court
because of
had reinstated.
Ramzan's,
No, court had reinstated. Just let us have a look at it. See, read paragraph 9. The dismissal order was passed on so and so, which was subsequently reviewed. Have you come to page 25, only 25, 25,
25.
25,
Yes.
paragraph 9. The
I
settled.
find that the impugned orders bad in law, the wisdom of such did avoid by
Having found the
Sure.
inquiry report was not
this
furnished.
special order was that.
Yes.
Yeah. Yes, but that liberty was given, which was ultimately not followed. And in any case, my lord, even this order was passed in 2008. No, he filed the
Now we are only on the period of 8 to 10. Later
to
period,
10.
we are not to.
Ultimately, the principle would be remain the same, my lord, that he has not worked, my lord, in that post for that period of 2 to 8 to 10 also. And if
The
there
8 to
was
10, there was no order of either of dismissal. Rather, there was an order of reinstatement, which
there
he
was
had
an
not
order
done.
reinstatement, but he was still working at that post. But my lord, apart from the difference in the salary, the fact remains that the claim that he is making in 2020 is for that period of 2008 to 2010. So even that, my lord, would be under the normal principles, my lord, which have been settled by Darshan Singh and the other judgments, would still remain that it is an arrear of salary, even if it is under court. Because even if my lord, the contempt limitation would also be 1 year. And had it been a case of pension, the issue is different, my lord. Then successive wrongs continue. But here it is a case of arrear of salary. Well, I have also placed one short order of this
Jotham Kumar.
Jotan Kumar.
Well, that
And
is based on the
he has also-
division bench, arrears of salaries,
Yes,
simpliciter.
Lord, and that apart, my lord, the submission remains that, my lord, 2010 to 2019, he, my lord, worked in that post. He did not challenge the order of reinstatement, that condition. He worked.
Now, what is the relief if you are trying to understand what is the relief he is seeking?
That the relief that he's seeking is that right from 2003 up to 2010, when he was actually working in the post of in a clerical post, he should be getting the difference in salary for between the salary of an officer and the salary of the clerk. That is the relief that is asked.
No, that is the reason we are asking. That the decision to reinstate was taken in August 2003.
Decision to reinstate was taken in 2010, 26/5/2010, page 27. It is this letter, my lord, which clearly says that from 1/9/2003
No,
to
no,
25.
not that. You're not on that. In the initial order. Initial order. At page 19, I think.
29/8/2003.
29/8/2003.
Yes, that is
Yes.
the punishment order.
Punishment order.
Punishment.
Yes. That punishment, what did you do? He had previous record finding this so and so. You finally decided to reinstate you in the service in the initial stage of clerical grade.
Yes, so my lord, between that 2003 and 2008, he was not working at all because he was dismissed from service. So in fact, what he has got, that is, my lord, he, in all fairness, my lord, he has got that money. Because he was only reinstated after this. He did not, my lord, work in that because he stood dismissed as on 29/8/2003 with effect from that date. That is why, my lord, the order of reinstatement says 1/9/2003. So 1/9/2003 to 25/5/2010. He was treated to be in service, though he never did any work. But now he's claiming that I should get the salary for the officer.
No, he was treated to be in service, not without doing. He had done work as a clerk.
My lord,
As a clerk, because he was reinstated on 29/8/2003 as a clerk.
Yeah.
It's not that he was out of service.
No, my lord, but then the punishment order would be, my lord, 29/8/2003 in the absence of the stay. There was no stay of that order.
No, that punishment order of reduction, that was the specific matter of challenge in
No.
2005.
So now the claim is limited to that difference in the salary between the officer's salary and the notional increments benefits. Yes.
Now that is why we're asking from 2003 till the decision of the court.
Yes.
In 25/8/2008, that is a different matter. But after decision of the court to reinstate him.
Yeah.
In a post which is permissible under the law. You have done it after almost 2 years.
Yes, that has been done.
You apply your mind for that. You apply your mind past fresh orders on the, he has already reinstated,
Yes. In
subordinated.
2019, I believe. Is written.
You think if he's entitled to something? There are cases, Mr. Sharma, where certain percentages have been directed to be paid. It may not be 100%, maybe 25%, maybe 50%. Even labor cases, many cases are there under 11A. 11A powers are slightly different.
But in those cases, with all due respect, those cases would be cases where he was absolutely not paid anything, totally out of service. And in that case, also the labor code would also be empowered to give him that back wages if he makes that averment and proves that he was not having a gainful employment.
No, that is 17B, that's different.
That's
different.
slightly
That's different.
So in those
That's
cases,
if a award is under challenge, award for reinstatement is under challenge by the management.
those
17B is
cases will be
different.
cases where they are getting zero. My lord. Here he has got a salary. He has got the salary of the clerk. And he wants, this is a case of difference in salary. So there is a slight.
Here in the earlier round of litigation, my lord, liberty was given to the authority, my lord, to initiate departmental proceedings if advised from the stage of my lord.
They have not done.
They have not done anything. And they have complied they have complied the order, but with condition. That condition cannot be imposed.
That condition, my lord, has been challenged in 2008.
If, my lord, they want to comply with the order, they have to, my lord, comply with full.
No, that we may not agree. That there is a violation or their full compliance with it is complied. They
Complied, but my lord-
are free to give what would be a fit. You are given notional benefits.
Even
It's not that mind has not been applied or some prejudice has been caused. In fact, they did not go ahead with the de novo inquiry.
Yes.
They could have and made some other penalties, but fortunately they did not.
In fact, there are several cases, my lord, where, my lord, referring to the Ramzan Khan's case, my lord, my lord, there is a direction while, my lord, setting aside and quashing the impugned order of imposition of penalty without charging the inquiry officer's report, the all consequential benefit is required to be.
Show us.
My lord, I will come to that. My lord, I don't have that judgment today, my lord.
Uh,
But there is a judgment from our court.
This is Justice Goel's judgment. This is
In
Goel's
fact,
judgment.
Goel. This is Goel's judgment. This is the one. But authored by Justice Talapatra. Justice Goel was heading. Yes. This is the one. Yes. Mr. Sharma, you should have got this. We'll take this up tomorrow. Tomorrow is the last item. But we do not know how many matters will be there tomorrow. We'll try.
Or on Thursday.
Thursday also we can try, but not beyond Thursday. Thursday. Huh? Thursday, huh? Okay. But we have completed the hearing only for the purpose. He produced some, he also tried to look at something, maybe in favor of you and maybe in against you. Try to, okay. The matter has been heard substantially. Full stop. On the prayer of Sri D.K. Sharma, learned counsel for the petitioner. A slight accommodation is granted to enable him to place certain case laws. For published on Thursday. No, first. First, we have to fix many matters. What is Benson Bodley the
My
word?
lord, since your lordship has heard, my lord, it may not take some much time, my lord. on
Thursday we are seeing.
Thursday.
Okay, next.
Public.
I'm sorry, my lord. I returned by late night flight. That's why I took a nap and came. My lord, my learned friend has expressed anxiety that I'm retiring tomorrow. But so far, this is concerned, it has nothing to do with the retirement because in the rules itself of the Assam Gramin Vikas Bank, it provides that if the disciplinary proceeding has been initiated prior to the date of retirement, then the consequences can flow. It's not that that my retirement tomorrow will have any effect on this case. So, my lord, subject to what my learned friend says, my lord, if your lordship can take up this matter any day after 15th of August, my lord. Because your rules only provide.
That order we are issuing today itself, that there is no difficulty regarding that.
What is the issue involved?
My lord, so far the issue is concerned, my lord. A major penalty has been imposed because 2 loan account has become NPA.
You are a branch manager.
I was the branch manager, but there were other officers who were also involved. So far that transactions are concerned and all. So you can't pick up one individual and give him the entire liability to recover it from his.
2 accounts have become NPA. That is the only allegation.
Yes.
No, nothing else.
No. 2 accounts they have mentioned that they have become NPA. And we have also filed an application seeking for around as many as 29 documents. Although in the inquiry report, they have mentioned that we have given them those documents and all, but your lordship knows that if I can show that prejudice has been caused to me, that is the case. And this, the anxiety that which my friend was expressing.
When were you dismissed from service?
No, I have not been dismissed. It was asked to be deducted from my salary. My salary was reduced, and my increment, my basic pay was reduced by 10 stages with cumulative effect. So let him retire.
How much is the amount involved?
My lord, in one loan account, it is 13,23,000, and in one case, second loan, it is 18,74,280. But there is a chain of officers who are involved. Is that Now some have been exonerated, but so far this is concerned, only this officer.
Mr. Ganguly, what are the charges? Only
So
loans
charges
becoming
actually-
NPA?
In very simple, no, that is not the one. What has happened in this case, my lord, he was the branch head of the Toysagar branch. And at that point of time, there were in several accounts, what has happened is that, for example, the agricultural land has been accepted as a mortgage. The sanction letter which has been sent back from the regional office to the branch, some conditions are deleted from that. And the loan amounts are disbursed, my lord, without checking whether the construction has started. So when we went for the recovery, we found that, my lord, all sorts of malpractices have gone on. And the fact is that, my lord, very detailed procedure has been followed. Every opportunity has been given, my lord, to the writ petitioner. He has contested. The DR on his behalf filed 16 numbers of document, no witness, my lord. And ultimately, my lord, the main ground that is there in this petition that I find is that
There was a defense representative.
yes, there was. He was represented. He was given every opportunity, my lord, that there is no procedurally, my
Okay,
lord, there is
okay, well,
infirm.
let us have a date when both of you
After
are ready.
15th August, because after my Murtali could happen. Any day after,
Any day,
after 15th,
hearing.
because that prejudice will not cause to him, my lord.
Okay, Sri B.D. Kaur, Learned Senior Counsel for the petitioner, prays for some accommodation. Full stop, para. Sri A. Ganguly, Learned Counsel for the respondent bank, however, has informed this court that the petitioner would be retiring tomorrow. Full stop. This court has, however, been informed that under the rules governing the services, comma, in case of but this penalty has already been
Penalty has been
If
stayed by
the-
this court.
Stayed,
The
there's a
recovery
stay
of the
order.
penalty amount has stayed.
But that will make no difference because
not make difference. The rules, rules also not necessary.
Three-judge bench decision also of the apex court, my lord, that can continue, recovery can also be made.
No, that's a different. That's a part. That
No
will be subject
observation.
to the outcome. We thought that see if during the pendency of a proceeding he retires, then you need to pass an order.
Yeah.
That
Yeah.
for the purpose of the inquiry, your ties will not be severed.
Yeah.
But here I don't.
Deeming fiction, ma'am.
Here I
this is already provided in the rule. So no observation is necessary because there is already an interim order.
লাস্টের কি করলো একটু না লাগে be that as it may, comma, this court observes that the I'm not retiring tomorrow, and there is a stay order. There is an interim order. Full stop. Be that as it may, come on. Matter is adjourned, and adjourned to be listed on. Listed on when? 20
Tuesday, ma'am.
Tuesday. 28.
We are obliged.
Public.
30.
Yeah. Your Lordship, I retired from Assam Rifles as Subedar Major on 28/2/98. I joined in 1961 as rifleman. Thus, I was retired from after completion of 36 years in the service at the age of 55 years. In normal course, I would have retired on at 58 or 60 years of service.
Why have you have retired at 55?
That's by regulation, rule 56J FR.
No, you have just said that normally you would have retired in 58. Okay. Or you have to either you reach 60 years, 58, or you have completed 30 years of service. Okay. Completed. You had completed 30 years of service.
36 years of service I completed
36 years.
at that time. 36.
That provision was the minimum 30 years service. If a person can complete a 30 years service, he can take voluntary time.
Oh, okay. Okay.
It was forced retirement in my case, whereas in my discharge memo, it has been mentioned as retiring pension. In PPO, it has been mentioned as voluntary retirement. Void memo number dated, this is in page number 30. Void memo dated 9/7/97, Assam Rifles in the exercise of the powers conferred by Rule 56J FR oblique Rule 48 of CCS Pension Rules 1972 informed the petitioner, informed me that on attainment of 55 years of age in February 98, I would retire from service.
Yes.
While acknowledging the memo that was served on me, I had specifically mentioned that I want superannuation pension as per directorate brochure issued to the unit and chapter 4 of the CCS Pension Rules 1972. Your Lordship, I am challenging the retirement order on the grounds that
Page 30 order.
Huh?
Page 30 order you are challenging. Page 30.
Please, yes, please take. Yes, yeah. Yes, sir, Lordship.
Okay.
I accept that the government no doubt has the absolute right to retire government officials prematurely on the ground of lack of integrity and ineffectiveness. I have mentioned this in page number 9.
What are your grounds of challenge?
My ground of challenge are Rule 25 under heading termination of service of enrolled person on ground of unsuitability says that.
No, this is not for unsuitability. I will come to you. Mr. Gogoi, why is the order passed? What is the justification? Page 30.
Annex 30, Lordship.
Yes, Annex P2.
P2.
Page 30.
Lordship.
This is the impugned order.
Lordship, whereas the Director General Assam Rifles is in opinion that in the public interest to do so. Sir, Lordship, attaining the age of 30 years, Lordship.
Yes.
Lordship, if the desired that the Lordship, as per Rule 48, Lordship, then the persons can be Lordship voluntary. He can go to voluntary retirement.
The option lies with the employee or the employer.
Lordship, even employee, if employee suggested Lordship, then employer has to give an undertaking.
No, can the employer on its own
No.
discharge? Employer cannot. So completion of 30 years is only a option to the employee
Lordship.
that he may go
He
for
may
voluntary.
go for
But
voluntary.
he says that he has not gone for voluntary retirement.
Lordship. That part, next up, P2.
Now, this is the order impugned in
Lordship,
this.
Lordship. That's no, Lordship. I'm checking Lordship reply.
Now, what is your cause of action now? Why have you come to the court? This was filed when? Which year? 2023.
23.
Regarding what? Pension? Correct pension or what?
Okay, correct. Pension competition also, and also what this one, because I was not retired in proper manner.
No, but that cause of action of 97 can you raise now? 2023.
Your
Pension computation, that's a different matter. We'll definitely examine. But a cause of action which might have arisen in the year 1997, 23 had come before this court.
Your lordship, in every communication he has been
That also
he has been
taken down
mentioning.
in our affidavit. That part.
No,
In
that-
every correspondence he has been mentioning about this, why I was forceful.
But your correspondence will not help. It depends. What is relevant for us is when you had approached the court. You approached the court for the first time in 2023. Your other aspect of pension will definitely examine whether it's been properly computed. But to challenge this, you have to overcome the grounds of laches. Huge delay. 97. Almost 25 years.
My lord, the fact is that how many people can afford to go against the government? It takes some guts
no, we'll not answer those questions. We'll go by the law. Law wants a equity court, wants you to come to the court diligently.
My lord, may I
1
again-
year, 2 years, 3 years, 25 years.
admit.
My lord, may I
There
kindly
will
come
be
to
delay.
page 30 again, lordship, may page 30.
Now, what about the other aspect? Can something be done on the pensionary computation?
Pensionary debt was also as per proper, there is no mistake, but we have stated in our affidavit. As per lordship pay commission, we have given.
No, let us see.
And
His-
lordship,
Let us see the order at page 53,
my lord, may before P2 kindly pay, P2,
52.
P2 lordship, page
P-
30 lordship,
Yes, yes.
P2 lordship. Here, his endorsement is there lordship. Acknowledgement part, then lordship, I want to superannuation. That is there lordship, in handwritten lordship.
But nowhere it is mentioned. Nowhere it is mentioned. I am taking voluntary retirement.
But I want superannuation pension.
Lordship. It's a declaration and acknowledgement by the lordship.
The moment you say that you want superannuation pension, that indicates that you have. And why will this order emanate if there was no request from you? As Mr. Gogoi has contended that the option is given to an employee that you can go for VR after 30 years of your service. They cannot forcefully retire you.
No, this option was never made. In his affidavit, they filed that it was by mistake we have so in their affidavit. I'm telling you, sir, Your Honor.
By mistake.
Yes, they have agreed that it is not. They say that in the website there are only two options where there: voluntary retirement and normal retirement. There was no of this retiring compulsory retirement, whatever the premature retirement they did. That option was not there. Hence it has come.
Where is it?
I'm showing you.
In our affidavit, we have stated. In our affidavit, we have stated, lordship. My lord, may kindly come to, in our affidavit, lordship, may para 11, 12, and 14 also, lordship, may kindly come to.
11,
Lordship may directly come to
11.
And lordship, kindly come to paragraph 9 at first, lordship. Paragraph 9, we have stated, lordship, here in technical part, paragraph 9. Paragraph 9, internal page 70, lordship.
Yes,
If lordship, I can read it, lordship.
yes, please.
That with regard to the statement made in paragraph 6 of the writ petition, the entering deponent begs to state that the petitioner proceeded on retiring pension with effect from 28 to 1998, which was clearly mentioned in para 2 of the PPO. At the category of the pensionist type, which means retiring pension, and also stated in discharge book issued in the petitioner that the reasons for discharge is retiring pension. Thus substantiate the fact that the petitioner proceeded the retiring pension under Schedule 1 of Rule 48 of Central Civil Service Pension Law 1972 on completion of 30 years of service. However, due to technical limitation of the CPAO website, where only two option is endorsing type of pension in PPO, that is voluntary retirement or superannuation pension. Since the superannuation pension is not applicable to the petitioner, voluntary pension was endorsed by the system by default law. It is not a case that lordship, and it is also pertinent to mention here that the endorsing of the voluntary pension in his PPO did not result in any financial or other loss whatsoever in his pension paper. Is there also. And even 9, 11 also we have stated lordship. And 12, 14 also that statement is again reiterated in the 14 lordship. Paragraph 14 in internal page 72 lordship.
That option of retiring pension was not there
No,
in the site.
lordship.
So he was shown to be voluntary pension, but he was given the effect of retiring.
No,
pension.
lordship, lordship. And regarding the application of Assam Rifles rules, lordship, that part also we have stated in paragraph 11, lordship.
Mr. Gupta, how do you overcome the delay aspect?
And lordship, till today, lordship, he is giving all the lordship benefit regarding revised pensionary benefit, all given. In paragraph 3, lordship, we have stated everything, lordship. Paragraph 3. Even lordship, 1 is due on 2023, that was also given, lordship. Revised pension, lordship.
How will you explain the delay, Mr. Gupta? Delay. How have you explained?
Your lordship, I am selling this order itself.
Now, how have you explained the delay?
Delay of
Equity court.
Of course, your lordship, I got no specific answer to your question. But the point is that he's an old man, and you see the information they get from other, because at that time, whatever after his retirement, the similar case arose in the court, as he has informed me, and many people were reinstated because they were having age and they could move to the court. But this man, not knowing, he was sitting in his village.
That's of petition, even lordship has dealt with. It is in respect of lordship medical category. Lordship has dealt with that category of petition. Medical category. No medical category, lordship, that part without issuing notice, lordship has already decided that particular.
At the time of filing, you are 80 years.
He is now 82 years age.
Not a fit case. Heard.
And lordship, now he is getting lordship. And what he is getting the pension, even 20% is more than that lordship, as per the scheme lordship.
No, that is enhancement after reaching 80 years of age. That we know.
This he has to get, he has not yet got so far. He's not got. No, आपने लिखे थे. You have written.
23 for
No, he is yet to be given. That is not given. So let's say one point I would like to put before you. That in this case of state of Ujjar made by Patel, the Honorable Court held that, you see, one of the, in page number 11, I've given.
No, we have read paragraph 13, you are referring.
Paragraph 13.
We have read this.
Yes, Lordship. And he was promoted only barely 1 year, 1 month ago, he was promoted as Subedar Major. And after 1 year, 1 month, they have put him. There was no adverse entry against him.
You are G.K. Gupta?
Yes.
Heard Sri G.K. Gupta, Learned Counsel for the petitioner. Also heard Sri K. Gogoi, Learned CGC. Full stop. Para. The instant writ petition has been filed with the following prayers, page 20. Please have your seat. As per the facts projected in the petition, the petitioner was appointed as a rifleman with the Assam Rifles in the year 1961, and in course of his service, he was promoted to the post of Subedar Major. Full stop. The grievance of the petitioner is related to the issue of his retirement. Full stop. Sri Gupta has drawn the attention of this court, to the order of retirement, to the order dated 9/7/1997 pertaining to his retirement. Full stop. As per the said order, as per the same, and as per the said order, which was issued in exercise of powers under Rule 56 within bracket J, small j, bracket close, FR/Rule 48 of the CCS within bracket pension, bracket close, rules 1972, notice was given to the petitioner that he would be attaining the age of 55 years on 2/1/1998 and would retire with effect from 28/2/1998. Full stop. The Learned Counsel has submitted that such retirement is forceful in nature and the petitioner should have allowed to continue till attaining the age of 60 years. 60 years. Full stop. It is submitted that at no point of time the petitioner had offered his voluntary retirement, and the impugned action amounts to a forceful retirement not contemplated in law. Full stop. It is submitted that similarly situated persons were allowed to continue in their service, and certain other persons were also reinstated after orders of this court. Full stop. The Learned Counsel has, for the petitioner, has relied upon the case of State of Gujarat versus Umed Bhai M. Patel, reported in 2001, 3 SCC 314. Full stop. The said case was on the aspect of compulsory retirement, wherein certain principles were laid down. Full stop. Para. Per contra, Sri Gogoi, the Learned CGC, has submitted has raised a preliminary objection on the maintainability, on the aspect of entertaining the writ petition. It is submitted that the impugned order is of the year 1997 and this writ petition has been instituted only in September 2023, full stop. By referring to the affidavit in opposition filed on 14/12/2023, comma, the learned CGC has contended that the preliminary issue of delay and laches have been specifically taken up in the said affidavit in opposition. Full stop. The learned CGC has submitted that the aspect of the challenge has also been explained in paragraph 9 of the said affidavit in opposition. Full stop. It is submitted that the system in place at that point of time did not have the option of retiring pension and had the only options of number one, voluntary pension, number two, superannuation pension. Full stop. Though the petitioner, due to exigency, was not due to necessity, was shown to be voluntary, to be under the voluntary pension, comma, no financial loss of any manner has been caused to him. Full stop. Rather, comma, all benefits have been given to the petitioner, including revised pension from time to time. Full stop. Sri Gogoi has also submitted that on completing the age of 80 years, comma, the petitioner would also be entitled to a hike of 20% in his pension. And therefore, the present is not a fit case at all for entertaining. Full stop. Para. The rival submissions have been duly considered. Full stop. The order, the communication dated 9/7/1997 had given notice to the petitioner regarding the aspect of retiring from service on attaining the age of 55 years. Full stop. The said notice, however, a close perusal of the said notice, however, would show that there was an acknowledgement by the petitioner in the following manner, in inverted comma, I want superannuation pension as per Directorate brochure issued to unit and chapter 41 of the CCS pension rule 1972, bracket, inverted close. Though a challenge has been made to the aforesaid order dated 9/7/1997, comma, the acknowledgement made by the petitioner would be in the teeth of the maintainability of such challenge. Full stop. Apart from the fact that the present petition has been instituted after about 25 years from arising of cause of action comma, if any, comma, this court has been informed, which are supported by materials on record, that all retirement benefits have been given to the petitioner, including the timely revision of pension. Full stop. This court is of the considered opinion that that the matter of retirement and payment of pension, which was settled in the year 1997, cannot be allowed to reopen after about 25 years. More so when this court does not find any illegality or irregularity in the aforesaid, does not find any ex facie illegality or irregularity in the aforesaid order. Full stop. Petition accordingly stands dismissed. Okay. Okay, nice. Item 51. Yes.
Lordship, here in this matter, Lordship, we have filed our affidavit, pleadings are complete, Lordship. But Lordship, subsequently, Lordship, I have received the statement of the petitioner, Lordship. The statement which was made before the inquiry officer, Lordship. So I want to bring that on record, but otherwise, Lordship.
It's a disciplinary proceeding.
No, exactly, Lord. My Lord, the fact is like this, Lordship. The petitioner is a employee in public health center. On some allegation, he was barred from the service without issuing any notice, Lordship. The informant lodged an FIR. He was arrested on the same day he was released. Thereafter, they, as per affidavit, they constituted a inquiry committee, but that was after dismissal him from the service. And the recorded statement of the petitioner as well as some other person. But in their affidavit, there is no statement of the.
Mr. Upamanyu said that there is some statement of the petitioner.
But they have filed affidavit.
Statement of whom?
It was the statement of the Lordship, the complainant, Vinita South, is there in the affidavit. And Lordship, one Lordship, NHM Lordship, one Dr. Karuna Akhtara is
No,
there.
where do statements given, copies given to the petitioner?
Lordship, everything was given to the petitioner, Lordship. The notice was also issued and his statement is also there, Lordship.
Now, what do you want to bring now?
Lordship, I want to bring the notice and the Lordship statement of the petitioner.
Matter of which year? Okay. when
My
you-
Lord, issue is very small.
24.
Okay, 24 matter, you bring
Yes,
it.
sir.
When? Thursday
weeks,
next?
2 weeks, Lordship.
Okay. On the prayer of your M.I. Hussain,
Lordship.
Heart Sri M.I. Hussain, learned counsel for the petitioner, para. On the prayer of Sri Upamanyu, D. Upamanyu,
Yes, Lord.
learned standing counsel, Health and Family Welfare Department, comma, matter is adjourned by 2 weeks to enable him to obtain certain materials pertaining to the statement recorded. Full stop. List after 2 weeks.
Lordship may pay for a date, Lordship.
24 matter, why date?
Lordship,
There are old matters pending. Why should
your
we give-
Lordship, your Lordship has decided many such cases, Lordship. I have two judgments also. Simple issue
There are old matters, Mr. Hussain. We
In-
have to be,
in violation of
we
national
have to be
justice.
reasonable. We are giving priority to 24 matter.
And-
There are matters of 14, 16.